I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.
All rise. 14th District Court for County, Washington, State of Michigan is now in session. All those for the court draw near. Honorable Judge Simpsons.
You may be seated. And court calls the case People versus Derek Hall.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Hall. Mr. Hall, if you could state your name for the record.
I don't know if he can hear us. Mr. Hall, can you hear us? Okay. You got it.
Okay, Derek Dwayne Hall. Can you hear me now?
Thank you, sir.
Okay, thank you.
Your Honor, today is the date and time set for sentencing. Ms. Pate did review the pre-sentence report with Mr. Hall, and they did not have any material changes, additions, or deletions. And we do ask that you adopt the recommendation.
All right. Mr. Hall, is there anything you want to tell the court before I impose sentence?
I'm sorry. Other than that, no, sir. Thank you.
Thank you. On count one, the use of controlled substance, $125 statutory fee, 168 days in jail, credit 168 served. On count two, the operate with the presence of a controlled substance, $50 statutory fee, 93 days in jail, credit 93 served. All right, you're all set. Good luck to you, Mr. Hall.
And what was it, 125 I owe?
Yes, you owe the state. You owe the state fees.
What are those? Could you tell me, please, so I can write them down?
Pardon? The
Could you tell me
total
state
amount
fees?
is 275, or I'm sorry, 175.
Okay.
Talk to your attorney about those fees.
Okay, thank you.
All right, thank you.
Thank you, Your Honor.
Court calls the case People versus John Coffey. They didn't have him up. Whose name was up there? Who's that?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Coffey, who stands to my right. Please state your name for the record, sir.
John Joseph Coffey, Jr.
All right.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Coffey. We have no changes or corrections, and we would respectfully request that the court adopt probation's recommendation. I will just note that Mr. Coffey does have a hold out of Fenton that he may be picked up after his release from incarceration in this county. So I would just ask the court would consider making the restitution due 6 months after his release from incarceration, wherever that may be.
Is there anything you want to say before I impose sentence?
And I'm thankful for everything the court's done for me since I've been here with the MAT program, and it's been a lot of help, so I appreciate it.
All right. Sentence of the court, $125 statutory fee, $1,212.98 restitution to Meyer payable through the court that will be due 90 days after release. All other 93 days in jail, credit 93 served. Good luck to you.
Thank you, Your Honor.
Court calls the case of the People versus Frederick. Is it Karakus?
Good afternoon, Your Honor. Attorney Jonathan Paul, on behalf of my client, good to see Your Honor and staff this afternoon. Frederick, please state your name for the court. State your name. What's your name?
Frederick Kriakos. All right. Go ahead.
Thank you, Your Honor. Probation was kindly enough to send me the evaluation and the recommendation prior to court today, allowed myself and my client to duly review that. We have no additions or deletions, Your Honor. Ultimately going to ask the court to adopt the recommendation. I have sent to probation proof of my client signing up for the victim impact panel. He is already in counseling. He provided a letter, which we provided to probation. Will continue to do that. He understands he also needs to attend AA, pay some fines and costs. We'd be asking for opportunity to have a payment plan on this case, Your Honor. I do see the recommendation for sober link for 30 days. It looks like my client has been compliant since he first got the device, kind of adjusting to that, but he has been perfect since then. I think he missed a couple tests early on, but we do appreciate the flexibility, allowing my client to get used to the machine, hit his targets, and have no issues. So we ask the court to adopt the recommendation, Your Honor, give my client to go on probation and continue his progress.
Sir, is there anything you want to say before I impose sentence?
No, Your Honor.
The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening assessment identifies the benefit of counseling and AA meeting attendance. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. So therefore, the sentence of the court, I will place you on probation for a period of 12 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. Do you have anything you can pay today?
Anything to pay today? No.
Should be set up as a payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual counseling with status reports to probation. You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. The sober link will continue for an additional 30 days in lieu of 4 days in jail. I'll order 90 days in jail. Credit 1, balance suspended.
Thank you, Your Honor.
Thank you. Let me pass, he walked out. Court calls case People versus DRA Theum.
Good afternoon, Your Honor. Paul Tefelsky on behalf of Ms. Thiam.
Right, go ahead, sir.
Your Honor, date and time set for sentencing. We did review the pre-sentence report. We have no additions, corrections, or deletions to make to it. I would ask the court to adopt the recommendation. As it notes in there, my client has 3 children. She's married. Her husband is a therapist. He's in the court with her. This case, Judge, happened in 2020 during COVID, and she was unaware of it until just recently, and then came in here and dealt with it. She has not had any other trouble since then, and she seems to be doing well. So I'd ask the court to adopt the recommendation.
Ma'am, anything you want to say before I impose sentence?
I'll just say I'm sorry about everything that happened.
Sentence of the court, $400 fines and costs. There was a bond. How much was the bond? 5?
Your Honor, the bond is 500. It's a 10%, so $50 will come off of that. I believe she also owes a $50 fee.
All right. $400 fines and costs will apply the bond. I'll order 90 days in jail. That is suspended. All right. Thank you.
Thank you, Your Honor.
Court calls the case People versus Brandon Bowe.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bowe, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Yes, Brandon Bowe.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Bowe, and we have no changes or corrections. And we would respectfully request that the court adopt probation's recommendation. Mr. Bowe is asking for 2 months to pay the $480 of fines and costs. He does have full-time work that he just started a month ago, so he's asking for 2 months to be able to pay that.
Mr. Bowe, anything you want to say before I impose sentence?
No, sir.
Sentence of the court, $480 fines and costs. I'm going to make that due and payable by June 30th, 2025. I'll order 93 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you, Mr. Bowe. You're all set.
Court calls the case of People versus Nicole Nelson. Both of them.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Nelson. She's on Zoom. Mr. Nelson, please state your name for the record.
Nicole Nelson.
Now, today's meeting has for sentencing. We did review the pre-sentence reports and don't have any material changes, additions, or deletions. I will say on behalf of Mr. Nelson, I've been working with him for quite some time. He has completely, I think, changed the majority of his habits since I started working with him. He has completed treatment and did transitional housing. As the court is aware and is reflected in the PSI, he has had some other issues up north. However, while speaking with him, he is dedicated to resolving those and getting everything back on track. He is living on his own now, and has acknowledged his struggles and wants to stay up there as he's leading a different life with different people. So I hope that the court adopts the recommendation as Mr. Nelson starts this new chapter of his life.
All right. Mr. Nelson, anything you want to say before I go to sentence?
Yeah, I just want to say I'm grateful that I was actually able, at that time, it wasn't the best experience, but now that I look back, I'm grateful that some things did happen in my past to get me to where I am now. And I'm just looking forward to growing and building my relationship with God and the community and being of service. So yeah, hopefully that this will keep me somewhat accountable.
And it's good to be alive, isn't it?
Amen. Yeah.
On the case ending in 1352, sentence of the court, 24-month probation term, $555 fines and court costs, $720 probation fees. How are you intending on getting that paid?
That might be a little difficult right now, but
are you working right now or no?
Yeah.
All right. Here's what I'm going to do. I'm going to have you talk to probation. I'll have you on a payment plan that's set up by probation. Okay.
All right. Sounds good.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to provide proof of Bear River inpatient treatment program or program completion to probation. Continue and complete outpatient treatment through Bear River with status reports to probation. You're to attend one AANA meeting per week with monthly verification to probation. Maintain employment with proof to probation. Report to probation on June 3rd, 2025 at 2 p.m. That will be a Zoom appointment, and then you'll report as directed. I'll order 365 days of jail, credit 57, the balance is suspended on that case. On your other case, 24 months probation, $555 fines and costs, that will be payment set up by probation. I'll waive the probation oversight fees on that case. There's to be no use of alcohol, recreational marijuana, any illegal substance. You'll be subject to random testing as requested by probation. You are also on this case to provide proof of Bear River inpatient treatment program completion to probation. You're to continue and complete outpatient treatment through Bear River with status reports to probation. There's to be no assaulted, threatening, or intimidating behavior. No possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to maintain employment with proof to probation. You're to report to probation on June 3rd, 2025 at 2 p.m. That's the Zoom appointment. And then you're to report as directed. I'll order 365 days in jail, credit 57, balance is suspended. Thank you, sir. Good luck to you, young man.
Thank you.
Court calls the case, People versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Yeah. Hello?
Hello, what's your name?
Mr. Reeves, can you state your name?
Yeah, can you hear me? I'm sorry.
I can hear you now.
Okay, my name is Cameron Reeves.
I need a camera.
Okay, hold on one second. Trying to get this shit up.
Mr. Reeves, you have to unmute and turn on your camera. Well, I don't know what he's doing now because he's staying muted. I'll pass the matter. Court calls case People versus Jacob Spellings.
Good morning, or good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Spellings, please state your name for the record.
Jacob Spellings.
Better today is the date and time set for sentencing. We did review the recommendation from probation. On behalf of Mr. Spellings, I also worked with Mr. Spellings for a couple of years now. He too has gotten sober. This is I believe, the longest time that he has been sober. He did complete treatment. He hit a couple bumps in the road during his time on probation on his other case, but was always very honest with me, community corrections, and we were able to work through everything to lead him to where he is now. I think he caught both of the cases that he's currently on probation for, in this case, happened in a close time period. And he's made those changes since then. Very respectful. I've really enjoyed working with him. I think the recommendation is appropriate, and ask that you adopt it.
Sir, is there anything you want to say before I impose sentence?
Yeah, just that I think the courts, I'm in a lot better place now than I was, a year ago. And I really think that this time being sober is going to stick. I get my kids back every weekend now. I'm going to get them for weeks at a time in the summer coming up, and I'm just looking forward to how living a sober life is going to be.
The court will know that I'm imposing a fines and cost sentence because he is already on probation to me in another matter. So in this case, it'd be $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs. When do you think you can get that paid?
It can be paid either later today or tomorrow.
All right. Why don't we say pay it by this Friday then, the 30th? Okay.
Okay, sounds good.
Fantastic. Pay that by May 30th, 2025. You're to complete an IOP program, included all recommended aftercare that already has been completed. I will order 93 days in jail, credit for the 3 that you served. The balance is suspended. All right.
Thank you, sir.
Spellings, good luck to you.
Thank you.
All right, take care. Court calls the case of the People versus Jack Lyons.
Assistant Public Defender Natalie Pate for Mr. Lyons, who should be present via Zoom. I do believe he made his final payment, however.
And Teresa Claire on behalf of probation, Your Honor, Mr. Lyons did stop by my office. He did provide me proof that he did pay the balance in full. He did have a conflicting court date. He wasn't sure that he was going to be able to get back here in time. I told him that I would waive him from coming since he completed all terms of a prosecutor deferred sentence. Given that all terms are completed, probation's asking that the court dismiss the case pursuant to the prosecutor deferred and discharge him from probation.
No objection to that, Your Honor.
Defendant having completed all of the terms, this case is dismissed pursuant to the prosecutor's deferred. And yes, and the defendant is discharged from probation with improvement. Thank you. For a recalls case of the people versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves. Mr. Reeves, can you please unmute and state your name for the court?
Cameron Reeves. Sorry, my camera, I turned it on and hung up. Apologies.
Okay, we've got you. All right.
Thank you, Your Honor. Today is a date and time set for sentencing. I have reviewed the recommendation, which is to re-refer Mr. Reeves for a PSI. He does state that he can make that in-person appointment next Tuesday at 1 p.m. and he does have the
Why
address.
didn't he get to his other one?
2 years ago, we do not recall, Your Honor. It was initially set in 2023. Since then, he has served some time in Wayne County. His recent failure to appear for sentencing last month was due to his incarceration there. Given that, we are asking that the court adopt probation's recommendation so that he can make his appointment and will have his pre-sentence investigation completed so that he can come back for sentencing on June 11th.
Defendant is re-referred to probation for pre-sentence investigation and report. He's to pay a $75 referral fee. He's to pay that by this Friday, the 30th.
Okay.
I'll set a new pre-sentence interview appointment for June 3rd, 2025 at 1 p.m. That is in person. I'll adjourn his sentencing to June 11th, 2025, 9 a.m.
Excuse me, Judge. Could I say something real quick, sir?
I wouldn't say anything about the case that we discussed, Mr. Reeves.
Oh yeah, it's just about the pre-sentence investigation. It's been it was rescheduled. This case is from some years ago, but it's been rescheduled 3 times since they rescheduled it for me since I was supposed to go. So I didn't actually miss it. They just kept rescheduling and pushing it back.
Well, you missed the one because you were in jail.
Yes, you are correct.
Yeah, that's a miss.
Okay. Yes, sir. All right.
All right. Thank you.
All right, no problem.
Thank you, Mr. Reeves. We'll be in touch.
Yes, ma'am.
I will talk to Mr. Goldstein and that's it for this block, right? And then I'll talk to counsel on Mr. Lee, and then I'll come back. Try to fix it up. Court stands in recess.
All rise. District Court for County of Washington, State of Michigan, time back in session. The Honorable Judge.
You may be seated. Calls case of People versus Calvin Lee.
Conrad Silver on behalf of Pittsfield Township.
David I. Goldstein appearing on behalf of the defendant, Calvin Lee.
All right.
Your Honor, we were here theoretically to be sentenced on a charge of reckless driving. However, for reasons that we discussed in chambers, I'm going to make a motion to withdraw that plea. I don't believe Mr. Siller is going to object. Once the plea is withdrawn, Mr. Siller is going to add a count of careless driving, and we're going to admit responsibility to that.
That is correct, Your Honor. I have no objection.
There goes the reckless.
The defendant's motion to withdraw plea on count 2 is granted.
And I do move that count 3 under MCL 257.626B.
So that's to careless driving.
That's correct.
And how does your client plead to that?
We're going to be admitting responsibility, Your Honor.
You're doing so on his behalf.
Yes, Your Honor.
All right. Court will accept that admission of
Whereas-
responsible to count 3.
We're going to be asking for an immediate sentence, Your Honor.
Fines and cost of $200. When can that be paid?
That'd probably be like a month or so, Your Honor.
Really, man?
I've been out
No,
of 3 years.
don't say it.
He was born here.
You just don't.
Come on, man.
I'll tell you what. Pay by August 29th. Now I don't have to look at that file again. Goodbye, Mr. Lee.
I'll let Jeff know.
All right. Court's gonna stand in recess, then we'll come back. We'll set up for the next block, come back and start calling cases again. Court's in recess.
All rise. May be seated. 14A District Court for County, Washington, State of Michigan is now back in session. The Honorable Judge Simpsons trial.
You may be seated. Court does call the cases of the people versus Dwayne Brady.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Brady, who's present via Zoom. Sir, can you please state your name for the court? Oops.
Hold on.
No, the 18 case is the.
All right.
Mr. Brady, can you please unmute and state your name for the court?
Yeah, it's Dwayne Brady.
Thank you, Your Honor. I did speak to Mr. Brady last week regarding the case ending in 638. That case, I believe, has a balance still of $275. Last week, Mr. Brady did state to me he believes he could pay that balance off this week. As to the other case, I believe there is a balance of $960. I would ask that the court cancel the warrant in that case and ask if Mr. Brady could give an explanation as to when he believes he could get that balance paid.
Go ahead,
I
sir.
could have that paid off probably in at least 2 months.
So, Your Honor, I would ask for an adjournment of the show cause in the case ending in 1686. If
Well, that one's not set today.
No, it is not, it is a warrant.
so, I would ask.
So on 638, I will indicate that the defendant is to pay this balance by. You could pay it by the 30th, sir?
Yes.
Pay that by May 30th, 2025. Then on the other matter, just make sure what we got here. Well. Okay, on this matter then, what on the 18 case ending in 1686. I'll cancel the warrant. When can you make a payment on this? Sometime.
I can make a payment next Friday.
The same day as the other one?
Is that Friday or next Friday?
You want next Friday the 6th?
Yes.
Okay.
That's when I can
I'll
start
cancel
paying
the
on that one.
warrant. I'll cancel the warrant in this one. Give them a PR, $5,000 bond. Defendant to pay, how much will you pay by the 6th?
I can pay 200 on it on the 6th.
Pay 200 on June 6th, 2025. When's my next day?
We have June 11th and June 25th.
25th.
Yes, sir.
And then I'll set for a show cause hearing June 25th, 2025, 9 a.m. or as your invite indicates. Okay. Thank you.
Thank you, Your Honor. Thank you, sir.
Thank you.
Court calls the case, People versus Ashley Fuster.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Fuster, who stands to my right, please state your name for the record, ma'am. Ashley Fuster.
All right. She currently has a balance of about 1,100.
Yes, Your Honor, and I was unable to have a conversation with Ms. Fuster prior to today. I didn't have good contact information. However, she is here and ma'am, do you know when you would maybe be able to start making payments on the balance?
So I actually plan to make a $200 payment today. I just have to get home and check the mail first, and then I plan to have the rest of it paid off in the next like 3 months. Really?
Say that first part again.
Oh, I'll be paying $200 on it today. I get paid paychecks and they come in the mail. So when I get home and can check the mail, I'll pay $200 on it today. I made some payments since I got the notice in the mail a month ago. This is from 2018, so I just entirely forgot about it.
Okay, so you're gonna pay $200 today.
Yes.
And when are you gonna make another payment?
I'll get paid 2 weeks from then, so I'll stop. Safely, I'll say 150 for the next week. My plan is at least $200 every month. Yes. If I can afford more, I will.
So you're gonna pay $200 today.
Yes.
And defendant to pay, what, 150 by what, the 6th?
Yeah.
Or the 13th?
The 6th.
By June 6, 2025. And then 200 per month. Beginning in July. Okay? All right. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Samuel Hamilton.
Assistant Public Defender Laura Kearney on behalf of Mr. Hamilton. Oh, Mr. Hamilton's here. Awesome. Hamilton, please state your name for the record.
Samuel Hamilton.
Yes, we are.
Still in the hospital.
A show cause, yes, as the court may remember, Mr. Hamilton got into a bad car accident and was paralyzed from his neck down. I have been trying to get in touch with Mr. Hamilton about proof of that accident, but we've not been able to make contact. Not sure if I have the wrong number for you or, did you get my email?
Yes, I got your email.
Okay. So.
I'm done.
Okay.
He's appeared before me every time in the same place, in the same hospital bed. I get it. I'm gonna waive all fines and costs except the statement. Mr. Hamilton, you take care of yourself.
Thank you. I really appreciate it.
All right. Court does call the case, People versus Donald Holloway.
There is no counsel on this one, and I don't have.
Yeah, my name is Mr. Holloway. Sir? Mr. Holloway. Your first name's Mr.?
Donald Holloway.
All right.
How you
I
doing,
didn't know.
Mr. Simpson? Okay.
You name their kids all kinds of things. All right. You owe $1,197.68.
Yes, sir. I've been paying, I'm on Social Security, but I'm gonna still pay another payment today before I leave. And I'll keep my payments up each month. I already made an agreement and I keep it up.
So you've been paying on it?
Yeah.
How much are you paying?
I've been paying $20. My wife made the agreement.
$20 a month?
Yeah. Yeah. And we just got a check yesterday, so I'm about to pay my other $20.
Pardon? Okay. Why is this set before me if he's been keeping his pay?
I see it in January.
So you haven't been paying per month, which is how it's coming before me.
Oh, okay.
You have to pay each month.
Oh, I was in the hospital, so that's probably what happened. I got surgery and all that stuff.
So I'll just put in here, he's paid $20 per month. We'll continue that and we'll start that June.
Okay.
All right.
All right, y'all have a nice day.
You do the same. Mr. Hamilton. Courthouse case people versus Robert Lee. Doesn't have claims.
Judge Simpson.
Good afternoon, sir. Can you state your name for the record, please?
My name is Robert Scott Lee.
Okay. You're here on a show cause. I have you owing $540.
Yes, sir. I won't even try to offer. Well, I just don't. I'm on a fixed income of $1,000 a month, and trying to pay $500 at one time is virtually impossible for me. So I was hoping that I could make some sort of arrangements, payment arrangements.
Okay, how much do you think you can pay each month?
Well, the gentleman that just left, he's paying $20 a month. If I could do that.
Hold up.
No, I'm
no, I'm gonna try to get the same payment plan. Why do you? No, you can.
Well, $20 a month
See,
is
it's
doable for
funny.
me.
No, don't be looking behind you because you know I'm talking about you. The moment you said that,
The moment I said,
well, I want the same payment plan as he had.
oh,
They started laughing. Yes, you did. Don't shake your head. You know you did.
okay, I'm sorry. I didn't mean to. If I
No, you're all right. You're okay.
But yeah, $20 a month would be
How much-
awesome. That would
How much
ensure.
do you get each month?
Each month I get approximately $1,045.
Pay $25 a month.
Okay.
Would that work?
Yes, sir. I can live with that.
That's because that's what they said you should pay.
Okay, all
I
right,
would
well-
live at the 20, but the one in the black, she said, give him more money. She was mouthing it up.
I'll deal with you later.
All right.
So 25.
No, the only reason he has 20 is that was set up with our collectors. Don't set anything that low. So but I'll give you $25.
Yes, sir. That I appreciate that. Thank you, sir.
Beginning in June. All right, sir?
Okay.
All right.
Thank
Take
you.
care of yourself.
Just one question. Can those payments be made online? Do you know?
They should be able to, correct?
Yes.
If it's got a warrant on it, you should be able to make it online.
Okay.
All right.
I can probably ask it when on my way out.
Yes.
Okay.
They'll be
Thank you,
happy
sir.
to
I
answer.
appreciate you.
You take
Judge
care of
Simpson.
yourself.
You do the same, sir. Thank you.
Court calls the case, People versus Keith Malone.
Good afternoon, this is Public Servant Mark attorney on behalf of Mr. Malone. Mr. Malone, please state the name for the record.
Keith Daryl Malone.
Thank you.
Warren, we are here for a show cause. I did speak with Mr. Malone regarding this file. It is from living in a nursing home due to some medical issues that he has. Any income that he gets goes directly to the nursing home for his medical care. So he has no income at all. He did, he said that he filed an ability to pay for him with the help of his case manager.
He did.
Um,
I see it.
So, given all of that, I think at this point he's unable to have support to consider waiving everything.
I've already written what I'm gonna do. You wanna keep talking?
No,
Okay. Why are you laughing, Mr. Malone?
I just laughed at you because last night I did a whole probation for you. You know that, and I was just thinking go Tarpons had to say a Tarpon team. I watch you every day. I happen to see my name come up. I'm watching one of your things, right? My son got the same name. I was like, wow. Then I called it was me. It happened in 2019. I'm like, wow, I ain't have no money left. Since I got another knee surgery coming up, I can walk. I'm still clean and sober. I'm motivated speaker now for drug and alcohol. So I'm doing that, but I don't get no income from that because I'm helping other people stay clean and sober. I think, man, Judge Simpson and Judge Barr had me going through these programs. Now I'm clean and sober 3 years now, due to the court and myself, but mostly myself and my help. And you were a good help to me too. You know, I know that very serious. You know, and
Thank you.
I would just like.
Thank you for saying that, sir.
Yeah, you are.
I do appreciate it.
Yeah.
I'm gonna waive all his fines and costs except the state minimums. You're all set, sir. All right. Good luck to you. Take care of
Yeah,
yourself.
thank you, Judge Simpson. Have a good day. Go Tarpons.
All right.
Yeah.
Court calls the case, People versus Lee Parker.
Assistant Public Defender Natalie Pate on behalf of Mr. Parker, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name to the court? Your Honor, I do not have an explanation for Mr. Parker's failure to appear. Number for him, I do understand he still has a balance of 569. For the record, I would respectfully request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set amount $7,500. I'll give a 10% privilege. That warrant will issue immediately. And he also does have another warrant out of 1482, so. Court does call the case of People versus Donald Pittman.
Assistant Public Defender Natalie Pate on behalf of Mr. Pittman, who's approaching. State your name, sir.
Donald Pittman.
Thank you, Your Honor. I have had the opportunity to speak to Mr. Pittman about this matter. He does still have a balance of 410. He thought he had already paid this. He did then provide me proof, and I did double check in JIS that he did not pay on this case. However, he did make a $276 payment on a ticket case on April 4th of this year. To that end, Mr. Pittman is asking for an adjournment of the show cause. He does receive SSDI in the amount of $1,300 monthly. He states he would be able to pay roughly $100 a month on this matter. So I'm asking if the court would consider a payment.
Would he begin paying now?
Next month, if that's okay.
What day do you get your check?
On the 3rd.
On the 3rd.
Yes, sir.
All right. You're to pay $100 per month beginning June 6th, 2025.
Yes, sir.
Till it's paid in full.
Yes, sir.
All right.
Thank you.
Thank you, Your Honor. Thank you.
Court calls the case People versus Shania Reed Ginyard. No counsel. Reed Ginyard. No response. What do I have, sir?
465.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. So give 10% privilege. That warrant will issue immediately. Court calls Jessica Shaw.
Good afternoon, this is Public Defender Warren County on behalf of Ms. Shaw. I don't see Ms. Shaw here in the courtroom. I did attempt to make contact with her. I was unsuccessful. I don't have an explanation for her failure to appear. I would ask for the
Yep.
634.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. Give 10% privilege. That warrant will issue immediately. I'm like parched. No.
Can I
I'm like-
do something to drink, Your Honor?
Did you have a moment?
Just don't do anything important.
Okay, I won't. Trying to hurt me. Court just called the case. People versus Sadibi.
Assistant Public Defender Natalie, on behalf of Ms. Sivity, who may be present via Zoom.
Thank you, Ann.
Ma'am, if you're there, can you please unmute and state your name for the court?
That's good, Alan.
So, Your Honor, I was able to leave my client a voice number, last number our office had for her. I do not have an explanation for a failure to appear and would request an adjournment for the record.
Yeah, Ben's warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000 of 10% privilege. That warrant will issue immediately. Court calls case People versus Heather Skidmore.
Public Defender Natalie Pate with behalf of Ms. Skidmore, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Yes, good afternoon, Skidmore.
Good afternoon.
Thank you.
Ivor 325.
Yes, Your Honor, and I was able to discuss this with Ms. Skidmore. She is asking if the court would consider allowing her to do community service. In the alternate, she states she would be able to start paying $50 monthly beginning on May 30th. She is currently on probation to 14B, and it is my understanding, as well as hers, that she is completely in compliance with that probation. I believe testing is a requirement of that as well. She also states to me that she has been about 2 years sober since 2023 and is asking if the court would consider allowing her to do community service. Understanding the balance is $325. If the court would like her to pay that full balance, she's able to pay $50 monthly beginning the 30th of this month.
I'm not going to do community service. What I will do is $50 per month beginning May 30th, 2025. All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Skidmore.
Yeah, thank you, Ms. Pate.
Court calls the case People versus Joseph Swope.
Assistant Public Defender Natalie Pate on behalf of Mr. Swope, who may be assumed.
Both on.
No, the one ending in 1250.
Got it.
The other one's in 84.
That's it. You know where your client is or no?
No, Your Honor. For the record, I respectfully request an adjournment. I was able to leave a voicemail, however, at the last number my office had for him. I did not hear a response. I respectfully request an adjournment for the record. I believe the balance in this case was $395.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $5,000. 10% privilege. Warrant will issue immediately. Court calls case People versus Henry Williams.
Assistant Public Defender Natalie Pate on behalf of Mr. Williams, who may be present via Zoom. Mr. Williams, if you're present, can you please unmute and state your name for the court?
No.
Your Honor, I did send him the Zoom and leave a voicemail. I did not hear back from him regarding this. For the record, I respectfully request an adjournment. I do understand, I believe there's still a balance owing of 70 and 40 cents.
Bench warrant will issue. Bond set in the amount of $15,000. Give a 10% privilege. That warrant will issue immediately.
Thank you, Your Honor.
Cases of the People versus Susanna Williams. They're both on? No.
No, the 2019 cases.
Got it.
The other was a companion one, right? I'm
Hello, good afternoon.
Hello, what's your name?
Susanna Williams.
All right. On the case that you're here before on right now, you owe $920 on that case.
Okay, I wasn't aware of the fines or exactly how much, but I was prepared to make a payment today, so I was just under the impression that when I did the 93 days for that, I didn't have any fine. No. I already did 3 months in jail for the donut case for the $5. So I didn't think I had to pay 1,000, but I have like $50 I can pay today and make $50 payments.
And you can make $50 payments each month.
Yeah, I live check to check or month to month, and I'm fighting for disability. I only get $500 a month, so I'm getting like half of what these
Pay
people make.
$50 today
Thank you.
and $25 per month
Perfect.
until paid in full.
Thank you.
All right, that's on that case. You also
I have, go ahead.
2 warrants. Let me just make sure. No, it's the same case. I'm sorry.
Go ahead.
1 warrant.
Mhm.
Another fines and costs. You did.
I think it was for the same thing. Oh, sorry. I just lost the middle.
That case, you owe $414.
Oh, it's the same case, but 2 separate fines. 2 separate
The
cases.
case we just did is this one.
Okay.
This one,
Can I make $25 payments on that one
hang
then?
on.
Sorry.
I'm gonna cancel your warrant.
Okay, thank you.
Give you a PR.
Perfect, thank you.
Since I put 25 on that one, I'll say defendant to pay 25 on this one.
Thank you.
All right.
How much total today then? Because I didn't bring.
Oh, you got $50 today.
Okay,
Pay the 50 on the one case that you're here on.
yeah,
And then
okay,
it's gonna be $20 per month beginning in June on each of these other 2.
okay, that'll work. Perfect. I can do that.
All right.
That's all? I'm not going to jail today?
Want to? You should.
Hell no.
Being a-
I'm sorry, I said it in the court. I was the first day I've ever been, I was nervous coming because I came at like 8 this morning. Like I lost the mail, so I just
Okay,
knew it
they
was
sent
you.
you to jail already.
But no. I'll just go pay the fine. First time coming to court where I don't gotta go, I'm not turning myself in or anything. I'm good.
You sure you don't wanna go?
I'm perfect. I'll be all right. I think I'll be good.
We got room.
I told you I did the 3 months
Then I'll
for some
take-
whole ass donuts,
You're all
some
set.
salty ass, some stale donuts.
All right.
All right, bye, hon. So 50 today
Yes, ma'am.
and 25
Yes, ma'am.
or, yeah, I'll figure it
On
out.
each case.
I think that's what it was that I went to pay the payment and I didn't know I had 2 cases.
Okay.
Have a good day, Judge.
Take care.
You.
Not talking to you. So hold it. Why? Who are they back there? You don't have a case?
No, we're here for Kayla Key.
For who?
Kayla Key. Is she in custody? Yes. I'm thinking you need to be in court with me.
Oh, you might be in the wrong court. So I'm sorry. I didn't mean to blame you for everything that, okay. You got- Oh, there you go. Ms. Lonnie. Yes, sir.
Good morning, Your Honor. Ashley Lundy for the people. At this time, people waiting in conflict between this honorable court and the Office of Public Defender. People do not believe that any conflict exists, make way for the avoidance of all doubt.
Thank you. Mr. Brown.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflicts so that this honorable court could hear these matters.
The court, thank you, sir. Court for its part also does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, People State of Michigan versus Charles Dane. Charles Daniels.
Yeah.
For Douglas for the people.
The council status.
No, he's still moving. It's off my end.
Council, you want to state your appearance?
Judge, I'm here. Can you hear me, Alex?
I can hear you now. State your appearance, please.
I want to be absolutely proud. President from the San Antonio.
I don't know where you are. I'm having trouble hearing you. Mr. Daniels, can you state your name?
Charles Anthony Daniels.
Thank you. What are we doing on this case?
Judge, we're just setting this matter for a preliminary response.
Is all discovery complete?
All discovery is complete.
People have their witnesses available to 10.
Yeah, we will do our best.
Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr. Bond will continue. Thank you. Court does call the case of the people or cases of the people versus Shanoa Harris.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Edward Dukas on behalf of Shanoa Harris.
Your Harris.
Hi. Your Honor, I'm still obtaining some discovery in this matter. I'm asking for an adjournment.
Just on so freely.
All right. Today's 29. Probable cause conference will be adjourned to June 12th, 2025, 9 a.m. Yes, Esteban.
Your Honor, it's come to my attention, the defendant has been contacting me with jail calls. One call specifically is cause concern. She asked her to get a PO box she could send mail to. I have concerns for her well-being, as well as the defendant violating her bond. So I'd ask that her phone privileges be revoked as well as her mail privileges.
Respond.
Your Honor, I haven't heard any of the phone calls. I'd like to obtain those prior to making any decision.
The issue with the mail, certainly we will let the jail know. The revocation of that becomes somewhat of an issue, but they do have a way of figuring that out. But at this time, what I will do, and certainly, Mr. Dukas, you can request a hearing. I'm going to grant the people's motion. Defendant's phone privileges shall be revoked. Pending a hearing. Thank you. 12. Thank you. Let's call the case of the people versus Andrew Patton. This is that case.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino, on behalf of Mr. Patton.
Where is he?
Unfortunately, Judge, his whereabouts are unknown at this point. I know there was some confusion as to.
Oh, I had no confusion. I don't know.
I'm sure you.
I don't know who else decided they had some confusion, but I had no confusion. He is supposed to be my guest at the Washington County Jail, and he is not.
No, you get the approach on this matter.
Your Honor, Wendy Barnwell, P42505, on behalf of Mr. Priester.
Name, please. Priester. Thank you. What are we doing?
Your Honor, in this case, Ms. Constantino was actually just getting ready to discuss with Ms. Barnwell for the co-defendant, whether they wanted to potentially set a joint or separate exams. And I think we wanted to set it out a bit, if so, because there's still some discovery coming in. So I'll leave that to Ms. Barnwell. They haven't gotten a chance to speak yet.
There's still outstanding discovery.
There's still things coming in. They had some search warrants out, and I think we're still receiving additional supplementary.
All right. What do you want to do on this, Ms. Barnwell?
I think set it out for an exam date.
Okay, but if any discovery you don't have, that's not going to be a basis for an adjournment.
Okay.
You understand that? Ms. Constantino, are you going to be doing that with your clients?
Judge, we can do that. I would just ask if we could get an exam date that was at least a few weeks out, because I know in particular, there is at least one report that we are waiting on that I know Ms. McDuffie does not have possession of yet that we need. So I don't know if the.
Are you
it might make
aware of
more-
that report, Ms. Burnwell?
No, Ms. McDuffie was telling me about it just now.
Do you guys figure it out, get it all together. I'm going to adjourn the probable cause conference, finding good cause to June 12th, 2025, 9 a.m. These are capital offenses.
I didn't hear you, Judge. What was the
June
date
12th.
for PCC?
For PCC, these are capital cases, you need to have all of that information.
Thank you, Judge.
Thank you. Court calls the case People versus Lozelle, Washington.
APA Richard McDuffie for the people.
Good morning, Your Honor. Edward Drukas on behalf of Larzell, Washington. Approaching.
Your name, sir?
Larzell, Washington.
Thank you, sir. The court has before the plea form. Is that what we're doing today?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading no contest to the charge of receipt and concealment of stolen property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct.
That's correct, Your Honor.
And you have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
State your name.
Larzell O'Neill, Washington.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of receipt, concealment of stolen property, 200 to 1,000 dollars. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Basis for the no contest plea.
Civil liability.
Sir, to that charge, how do you plead?
Guilty, sir. No contents.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because you believe, well, I won't ask you that. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-62111. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt. Counsel, have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be July 3rd, 2025, 10 a.m. before Judge Washington.
If I may address Bond, Your Honor.
Go ahead.
Mr. Washington previously was remanded for, or I had been picked up for a warrant for failing to show up to court. I have had several discussions with him, gone over this case, gone over what happened at his sentencing. He did interview with the recovery court. And now with him going to 14B for sentencing, I'm going to getting the paperwork ready for probation. He knows he needs to make and keep an appointment with probation. We're not objecting to any additional orders the court would impose. If the court would require him to test at community corrections, he would abide by that. He reports to the court today that he would show up to that sentencing, that he's tired of being tired, and he wants to take care of this. So we're asking for a PR bond. He has spent about 30 to 40 days in jail since he was picked up. And I think he understands the consequences of him not showing up to court, and the fact that this was reduced from a serious felony to a misdemeanor. We're asking for that reduction to a PR bond.
Response from the people.
Thank you, Your Honor. So my only requirements for the reduction in this case was that Mr. Washington participate honestly in the screening and referral process for the treatment court. I believe the court has the outcome of that screening interview. I don't have the full assessment report, but I wanted to get some sense of where he is. I have not taken a position on him being released thus far. The only request that I have is that he be ordered to test for drugs and/or drugs specifically, alcohol, I suppose optional, especially given the outcome of the interview. Mr. Washington is very adamant about not participating in treatment court, so I do want to ensure that he at least remains compliant.
Yes. Bond will be reduced to a $25,000 personal charge since defendant to test 2 times per week at community corrections. You understand that, sir?
Oh,
You're going-
yes, sir. And thank you, Justice.
Well, don't show up. I don't know. Judge Washington would be so generous.
I'm gonna
Show up.
Sure, sir.
All right.
Thank you.
You got to make sure that you test. Court calls case of the people versus Joe Kraut.
On behalf of the people, Your Honor.
Good morning again, Your Honor. Christina Costantino, appearing with and on behalf of Mr. Kraut, who is approaching. Stand right there. Mr. Kraut, can you please state your name for the record?
Right.
Judge, I was just appointed on this matter, I think actually this morning. So given that I do not have complete discovery, and so I would be asking for an adjournment of the PCC.
That objection, June 12th, 2025, 9 a.m.
And Your Honor, I did just want to put on the record, we did request a maximum call yesterday, so it should be in the next couple days.
Okay.
Thank you very much.
Continue.
Thank you.
Court calls cases of the people versus Rick Artuso.
Andrew Childers, on behalf of the people.
Is he in our lot?
He's got 2 lawyers, you know.
I'll just call him Lucky. Guess it depends on who they are, but.
I was gonna take a stray from somewhere today, Judge, so it's okay.
I was letting him push one up, and I can't walk on it.
Okay.
All right, go ahead, counsel.
Good morning, ladies first.
Good morning, Your Honor. Assistant Public Defender Chinazi Carey Akinrili on behalf of Mr. Rick Artuso on the 0436 matter, Judge.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as to the remaining matters, Your Honor.
All right. What are we doing?
Your Honor, we were just gonna set this for exam. The people have extended an offer, but it requires a substantial amount of restitution. Clients in custody is not really able to do that, so we're just gonna set it for exam. I believe the
We're doing that on our matter as well, Judge.
All right. So all discovery is complete.
That's correct.
People have their witnesses available to 10.
Yes, Your Honor.
Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Valvo in both matters. Bond will continue.
Thank you.
Thank you. Court does call the case of the people versus Christie Couch.
Andrew Childers, on behalf of the people.
Once the traffic clears, Your Honor, David I. Goldstein appearing on behalf of the defendant.
Your name, ma'am?
Christy Couch.
All right. What are we doing on this case?
Your Honor, there are 3 co-defendants. They're all set for PCC on the 12th of June. So I think Mr. Childers and I are simply going to ask this matter be adjourned over to that date.
Probable cause conference without objection, June 12th.
Thank you, Your Honor.
Thank you. Case of the people versus Danya Boone.
Ally, then on behalf of the people, Your Honor.
Yes, good morning, Your Honor. Robin, on behalf of Danya Boone.
Your name, ma'am?
Danya Boone.
Thank you. All right, what are we doing on this?
I am not aware of any offers at this time. We would like to address the bond, and they have a 2-year-old child in common, so the parenting time exchanges as well.
Gonna get it all into that. I'm trying to figure out what to do with this case today. Are we gonna set it for exam or what are we doing?
If there's no offer, yes, we would set it for an exam, Your Honor.
Your Honor, I just want to put on the record, we requested the 911 call yesterday, have not received it yet, so it's not in the file.
Okay. So the 911 call is the only thing outstanding?
I believe so.
Yeah. People, other witnesses available the 10th?
We'll do our best, Your Honor.
All right. Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr. As the
Okay.
bond.
And Your Honor, will that, I just want to be clear, it'll be Judge Barr, will that be on the Hogback location or will it be at,
It's at the service center. All exams are at the service center.
Okay. Okay. And then as to bond, so my client is 39 years old. She's been a bus driver for 15 years at the Lincoln Consolidated Schools, no prior record. The parties have a 2-year-old child in common. And so, as my understanding, this is an isolated situation. Nothing like this has ever happened before. They do have, there's she's collecting child support from the complainant. And so we're requesting that she have a PR bond. We would want to see if they can have contact, I guess, via app close. And have the parenting time exchanges at the Ypsilanti Police Station on Michigan Avenue, where it's my understanding, the complainant lives by that location, and that, as my understanding, the stepdad could do. Mr. Maurice Davis has agreed to do the exchanges. The child right now is with the maternal grandparents.
Respond.
I would object to any change of bond. This case is extremely serious. It involves her stabbing the victim in the chest. He was found laying on the couch, bleeding profusely. He had lacerations to his hands, his forearms, his shoulder, a puncture wound to his chest. At the time she was arraigned, he was unconscious in the ICU. I have not heard anything from the victim regarding contact, and I would object to any change in the conditions of the bond and ask that it remain as said.
And Your Honor, if I could just briefly respond, my understanding is that there was a party, there was drinking involved, there were several people there, and that the complainant was not clear on who stabbed him. I don't know, I wasn't there. But my client has had nothing. She's never had anything like this before. It has been gainfully employed as a bus driver for Lincoln Consolidated Schools, which my understanding is that she would have that option to go back to school to support herself and her child. If she's incarcerated, she won't be able to do that. And the child is in the care of the maternal grandparents. And I don't, I think dad is paying like a small amount of support. So, yeah.
There were witnesses at this party who saw the defendant with the knife in her hand after the victim was stabbed.
Motion for bond reduction is denied. Bond will continue. Thank you.
Could we have have a referral over for pretrial services for an evaluation on bond, or?
I don't care what you do. I just listened to the argument on bond. Her bond, and I don't know who you'd send it to. Ms. McCoy, if you want it sent to somebody, you figure out who it's going to be sent to. Her bond was set before the magistrate. The magistrate did their assessment of it. I've listened to your argument. Bond is denied. Bond will remain at $500,000 cash surety. Thank you.
right, thank you, Your Honor. Oh, wait, Your Honor, what about, so she's incarcerated, but the child is with the maternal grandparents. Can we have it where they just have the parenting time exchanges with the stepdad at the Ypsilanti Police Station? For dad to be able to see his son?
I am not doing that.
Okay,
Thank you.
thank you, Your Honor.
Court calls case, People of the State of Michigan versus Paul Ali. Madam Mayor.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Where's Bekovich?
Michael Gaddy, Assistant Public Defender for the defendant. Your
Mr. Ali, can you state your name, please?
This is for Al Ali.
Thank you. What are we doing on this case?
Yes, Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ali, who will be requesting a 2-week adjournment to obtain some additional discovery.
Any objection from the people?
Yes, Your Honor, it is an objection. I thought we just spoke about this
Okay.
case.
We spoke about Mr. Amerson, not Mr. Ali. Mr. Ali was the one who I asked for the additional discovery on. I have 2 cases up with you this morning.
Right, and I object to the adjournment because I sent him the information in terms of what we're offering. And I just think a decision at this point needs to be made in terms of what's going on, but I don't know what he means by additional discovery, so I'll leave it to discretion.
I don't either. So what other stuff are you looking for?
My client would like a full accounting of the matter.
The what?
A full accounting.
So a full accounting of the child support?
Yes.
So if he went down to the FOC, you could get that at any time, quite frankly.
Understood, Your Honor.
So if I don't grant the adjournment, what are we going to do? You want it set for exam? Are you ready to go?
Could we pass this matter so I have a moment to speak with my client?
Madam AG, you have another case, right?
Yes, I have 4 more with you, Your Honor.
4 more? Okay. I'll pass it. And court
Thank
does
you.
call the case, People versus Demond Bransford.
Good morning, Your Honor. Christina Barragarian requesting permission to practice pursuant to Michigan Court Rule 8120 under supervision of Assistant Prosecuting Attorney Ashley Long.
You're under her supervision?
Yes, Your Honor.
Are you? How's that going?
It's going well, Your Honor.
Is it?
Yes. Yes, Your Honor.
With Londi?
Yes.
Really? She must be nice not to know anything. Okay. I'm kidding. Permission to practice is granted.
Thank you, Your Honor. Christina Barragarian.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bransford.
Where is he?
He's in Zoom.
Yes, he's on Zoom, sir.
Sir, state your name. There he is. Hang on.
Demond Bransford.
Thank you.
We'll be seeking a 2-week adjournment for negotiations. Mr. Bransford, I'll be coming to speak to you soon. The prosecutor rejected my proposition, so.
Probable cause conference will be adjourned without objection, June 12th, 2025, 9 a.m. Bond continued. Thank you. Let's call the case, People versus Rafael de la Cruz.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. Kelma Dadish on behalf of Mr. De La Cruz. Is he on the Zoom?
I do not. Mr. De La Cruz, you have him?
I thought it was at 12:30.
What?
I believe the Zoom link that I received said it was at 12:30.
It shouldn't have.
So I told him
It's
to
an
enter at
AG
12:30.
case, but
He's not gonna have
he's
signed
on the
in.
cheat sheet for 9 a.m.
Your Honor, can we go off the record and approach please?
Well, I can't because I got her in Zoom.
Can we pass the matter, Your Honor?
I'll pass it. Right. Court does call the case People versus Dave Osseray Hennings.
APA Richard McDuffie for the people.
Good morning, Your Honor. Christina Castillo, appearing with and on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Vassier Henning.
Thank you. What are we doing?
This is the matter that we just adjourned for the co-defendant a little while ago out to.
I think it was June
Wow.
12th.
Probable cause conference adjourned June 12, 2025, 9 a.m. Bond continued.
Thank you, Judge. And just for the record, my understanding is that there still is outstanding discovery, and that's the reason for the adjournment.
Yes.
Thank you.
Thank you. All right, we got another AG case, so let's hope we can do one of them. Court does call the case People versus Clyde Moore.
I'm sorry, Assistant Attorney General Clarissa Williams on behalf of the people.
And good morning, Your Honor. Public Defender Chinazi Carey, I can really, on behalf of Mr. Clyde Moore. Mr. Moore, state your name for the record, please.
Clyde Moore Jr.
It's iPhone 1. All right, what are we doing?
Your Honor, I believe that we have a resolution in this matter. The last time we were here, Mr. Moore, we had indicated to the court that Mr. Moore had a zero balance with regards to his arrearages, and the people had extended an offer for him to plead to a disorderly conduct. I don't know if the court is in receipt of the plea form, but we are prepared to.
I don't have a plea form.
Your Honor, I asked the defense counsel this morning if you would need a plea, and I just found out about this morning. I actually was out of the office yesterday. I had jury duty, so I wouldn't have been able to do anything yesterday. But that is the agreement.
Pardon? What'd you say, Madam Attorney General? I'm sorry.
That is the agreement, that he pleads to a misdemeanor disorderly.
Disorderly. So
yes.
Can't you guys do a plea form and get the AG's approval?
Absolutely, Judge.
Something on one of her cases.
Absolutely, Judge.
All right. Well, we'll get a plea form prepared so I can take the plea today. I'll just pass it and put it in the AG stack, I guess, at this point. Okay.
Thank you.
All right, thank you. Court calls the case People versus Demarius Tubbs.
APA Richard McDuffie for the people.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court. Edward Martell, P 85051, on behalf of Demarius Tubbs, who stands to my right. Young man, please state your full name for the record. Demarius Tubbs.
All right, what are we doing?
Thank you, Judge, if I may. We were just recently retained on this matter. We do have paper discovery seeking outstanding video discovery. However, this morning I was notified that this case possibly may be going federal. So we're asking for a 2 to 3 week adjournment to sort this thing out, Judge.
Any objection from the people?
No objection.
Well, we don't have a 19. So I'll adjourn it to June 17th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Judge. Always a pleasure. Have a great day.
Yes, sir. Yeah, I'll call it. It's probably gonna go in a stack. People of the state of Michigan versus Daniel White. This is the last, I think. Huh? She has an in custody, okay. Daniel White. Go ahead.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. White, who's here via Zoom, Judge.
Good morning,
State your
Your Honor.
name, Mr. White.
Oh, sorry, go ahead.
Go ahead, Madam Attorney. No, it's in order to this. So you go ahead and state your appearance, Madam Attorney General, please.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
All right. Mr. Gaddy has stated his appearance. Mr. White, can you state your name, please?
Yes, Daniel White.
All right, what are we doing?
Your Honor, I've had a chance to discuss this matter with Mr. White. There is a a discrepancy in terms of what we think is the outstanding balance, but I have explained to me as an ultimate right to a preliminary examination. He wishes to waive that exam and proceed to circuit court in this matter and seek resolution there. I do have a waiver
Mr.
form.
White, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Gaddy.
We do waive reading of the complaint, stand mute, Judge. Acknowledge receipt.
Defendant waiving, acknowledging receipt, waiving formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for July 17th, 2025, 1:30 before Judge Slay.
Thank you.
Thank you. Bond continued.
What time was that? I'm sorry.
Pardon?
What time was that? I'm sorry, I missed the time.
1:30.
1:30. And will that
I'll give
still
you a
be
call after
available
court,
for
Mr. White.
Zoom?
Pardon?
I'll give you a call after court, Mr. White.
Oh, yes, sir. Thank you.
Court calls the case, People versus Antoine Amerson.
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Assistant Public Defender on behalf of Mr. Emerson.
Your name, sir? Antoine Emerson. Thank you. What are we doing?
Today, we will be waiving the preliminary exam to pursue the offer made by the AG in circuit court. Please want to sign my signature, please.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Right up here.
Mr. Buckovich, as to the circuit court arraignment,
As to the circuit court arraignment, we will waive the formal reading of the complaint and will be standing mute.
defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 10th at 1:30 PM with Judge County.
June 10th, 2025, 1:30 before Judge Filkey. Bond will continue.
Thank you.
Thank you. We'll get there. Court calls the case, People versus Allen Franklin.
And it's in on behalf of the people, Your Honor.
Good morning again, Your Honor. May it please this honorable court, David Burgess, on behalf of Alan Franklin.
Your name?
Alan Franklin Jr.
Thank you.
Your Honor, I spoke with the prosecutor on this matter. We're just going to set this for exam. Discovery is complete.
People have their witnesses available to test.
Your Honor.
Preliminary examination in this matter in person will be set June 10th, 2025, 9 a.m. That's before Judge Falvo. Bond will continue.
Thank you, Your Honor.
Thank you. So on the AG cases, I'm just waiting on Mr. Buckovich. Well,
Reading is that is
will somebody let me know when you guys are ready on the AG cases, please? Court calls the case of People versus Antoine Brooks.
Joseph and the people, Your Honor.
And Assistant Public Defender Chanazi Carey, Your Honor, on behalf of Mr. Anton Brooks. Mr. Brooks, state your name.
Anton Brooks.
Judge, we'd be requesting an adjournment today. I know the people did submit a motion to us. Mr. Brooks has indicated that he'd like to retain private counsel.
Before the motion's addressed.
That is correct, Your Honor.
That just came in this morning. Okay. How long is it gonna take him to get counsel? Okay, well, I don't know.
A month out,
I'm not going a month out.
whatever you can do. 2 weeks to do.
We have 2 weeks, Judge.
Set probable cause as well as the motion to compel DNA. I'll set that for June 12th, 2025. All that will be set at 3 p.m.
Okay, June 12th.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Neil Kessler.
Morning, Judge Lawrence H. Margolis with and on behalf of Mr. Kennedy or Mr. Kessler, who is approaching. Please state your name, sir.
Neil Kessler.
Judge, today is the first PCC. I believe there is more discovery that is outstanding or may be outstanding. So we'd ask for a short adjournment. And after speaking with Mr. Kennedy, if possible, we'd like to approach briefly on a small bond matter.
June 12th, 2025, 9 a.m. Approach. This time bond will continue.
Thank you, Judge.
Thank you. Court calls case people versus John Fulton.
Andrew Childers, Your Honor.
Senator Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. John Fulton. Mr. Fulton, please state your name for the record.
John Fulton.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We'll be waiving the preliminary examination and going to be go over to circuit court where we believe this matter can be resolved.
Is that correct, Mr. Fulton, that you're waiving your right to a preliminary exam?
Yes, sir.
All right. I'll let you finish signing there, but you understand that where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, been found over to circuit court.
Thank you, Your Honor. We acknowledge receipt of the information and we waive its reading on the record. My client was.
Bye, Constantino. Never mind.
Great to see you.
Yeah. Always a pleasure. Go ahead. I'm sorry, Mr. Brown.
My client will stand mute.
Defendant every way formal reading, standing mute, court will enter a not guilty plea as to all 3 counts. Pre-trial in this matter will be set for.
June 10th at 1:30 p.m. with Judge.
I'm sorry, Judge. June 10th, 2025, 1:30, Judge Comfy.
Thank you, Honor. May we address the issue of Your Honor, I've had a chance to submit a mitigation report to the prosecution. I've read it. At this time, we are asking that my client's bond be modified so that he can stay at the 2735 South Wagner Road address, Ann Arbor, Michigan. If it feels that a tether would be appropriate, my client would be happy to do so. We feel that the circumstances of this case warrant lease to that address. He is not a danger to the community at large. He will return to all future court dates.
Your Honor, Mr. Brown did provide me with a mitigation report with respect to his client. In reading that report, with some information provided, I would not have an objection by the defendant on a tether that he be released while this case is
home confinement.
I don't believe that he has a reason that would conflict with his life.
It's okay.
It's a defendant's bond at $30,000. Personal recognizance. Defendant may be released on a home confinement tether. That tether has to be in place prior to his release.
And which judge is this going in front of?
Good Conky.
Okay.
Thank you.
Thank you very much.
Okay, so that one might have to That's fine. Okay. So are they ready on the other? Court calls case first, Ammerman.
Thank you, Richard. That's for the people.
Morning, Your Honor. Alex Warren, Green on behalf of Ammerman. Your Honor, I reached out to Mr. Ammerman. We did not receive any correspondence in return. For the record, I'd ask for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set at 10,000 cash surety.
Thank you, Your
That
Honor.
warrant will issue immediately. Court calls case People versus Douglas Hill.
Thank you, Richard. That's for the people.
Stephanie Cannon. On behalf of Mr. Hill.
Your name, sir?
Douglas Hill.
Thank you.
Your Honor, we are going to be asking for a brief adjournment on this matter. But with the adjournment, we'd also like to address bond.
Without objection, probable cause conference, June 12, 2025, 9 a.m.
Your Honor, as
Do I have a
to
green sheet?
bond,
Do I have a green sheet?
I'm working on, Your Honor. I have a few of them in my hand. I'm so sorry. As to the bond, Your
I
Honor,
was going to be adjourned, I see. No need to comment. Go ahead.
thank you, Your Honor. And my pen,
Oh, Cannon, really? It's just one of those days.
it went under the lectern, Your Honor. My pen went under the lectern. I'm so sorry. Here we go. As to Mr. Hill, there's the green sheet. Thank you. I'll get it eventually. As to bond, Your Honor, my client has a appointment on June 2nd with the IRS regarding a very serious matter. He is requesting a furlough for that day, just so he can meet with the IRS. He'll come directly back.
Taxes?
So yeah, so he's, this meeting was set.
What it was about. And
Well,
he said taxes.
He said taxes.
Really? No, don't worry about it. I don't even know why she asked that
Well,
question.
yes, Your Honor. So it is a tax matter. I didn't want to go too far into.
No, I don't.
Okay.
If he's got the appointment, I just need proof of the appointment. Maybe I'll consider
And
it.
we can do it in writing.
Yet you'd have to do something in writing regarding that.
Perfect. Your Honor, in addition to that, as you know, my client was, the last time he was up, the court did remand him because he was testing positive for substances that he should not be testing positive for. My client at that time was trying to get into a treatment program. Matter of fact, he came from, he was after court, he was supposed to go be scheduled to be screened. My client is asking if he can be released to inpatient treatment if the court would allow that.
For inpatient treatment, if you send me an order that's stipulated to, certainly I will sign it.
Perfect, Your Honor. Then I'll make it
I'm not going to object to release the infant.
perfect. Then, Your Honor, with that, I believe we are all set.
Thank you, Your Honor.
And I'm gonna,
Thank you. At this point, his bond will continue. And I'm not saying, so that we're clear, I'm not saying I grant the furlough, but I need to see information. Thank you. Really, Cannon. Did you get your pen?
thank you, Your Honor. Yes.
Court calls the case People versus Roderick Bates. So. The dish is ready. Who's the other one? Buckovich and Shitnausen? Okay. Your name, sir?
Roger Bates.
I'm sorry, Mike Gaddy, Assistant Public Defender for Mr. Bates. Sorry about that.
What are we doing?
Your Honor, I'm asking the court for a brief adjournment to go over this matter, some more with Mr. Bates and to go over more discovery. I will submit a green sheet immediately.
June 12, 2025, 9 a.m. bond continued.
Thank you.
So you think they're ready on this? Let's see if we can get. Got other stuff to do today, I'm sure.
I believe you want to ready here.
Yeah, what?
I've been getting
Which one are you?
Clyde Borges.
Taylor Cruz, what about?
You have an
You can be ready?
Yes.
Well, didn't sound real confident, so I'll let you wait. Court calls the case, People versus Clyde Moore Jr.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Clyde Moore Jr. Mr. Moore, if you're still there, could you please state your name for the record? Turn your camera on too.
I haven't. He's not there. No, what are you calling him?
Just wanted to shoot a text, Judge.
I sat there and asked, were we ready on the Attorney General cases? Because this is now, she had 5. This is now the 8th case I've called, some of them duplicates. So are you expecting, Ms. Eckenruther, that I'm going to wait for him to respond to your text?
Absolutely not, Your Honor.
Thank you.
That's not my expectation at all.
He's not here. Clyde Moore? No response. Bench warrant will issue for defendant's failure to appear. How much is owing in child support?
No, Mr. Moore is the one who has paid in full, Judge. And
He's
we
paid
were-
in full, but
Yeah.
where is he?
He was on Zoom. I think he might have misunderstood us passing the matter and may have logged off.
This is the plea.
This is the plea. That is correct, Judge. I have the paperwork
You
here.
have the form,
I do.
but you don't have a client.
Yeah.
He needs to show up before I finish with the Attorney General cases, or I'm issuing a bench warrant, plea or no. And we'll have a captive audience. Court calls the case People versus Rafael de la Cruz.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
On behalf of Ms. De La Cruz, Your Honor, can we please approach?
No, you don't need to approach. You're looking for an adjournment because the wrong time may have been sent to you. My staff has informed me, they can't verify it certainly, but they think that the wrong time may have been sent to the defendant. So in that instance, I will adjourn it.
Thank you, Your Honor.
See, unlike some people in your office, I take responsibility for what we made you.
Every time I
June
take
12,
it.
2025, 9 a.m.
What's the date, Your Honor? I'm sorry.
June 12th.
June 12th. Okay, thank you.
Thank you. Yeah. Court calls case, recalls case, People versus Foul Ali.
This is the public defender on behalf of Mr. Ali.
Assistant Attorney General Clarissa Williams on behalf of the people.
Mr. Ali, can you state your name, please?
Ali.
Thank you.
After speaking to my client, he will be waiving his preliminary exam. I have a signed preliminary examination form, which I signed with his permission to pursue the AG's offer in circuit court.
Mr. Ali, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing, that you'll proceed to circuit court for further resolution?
Yes, Your Honor.
All right. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Becker.
Yes, as to the arraignment, we will waive the formal reading of the complaint and my client will be standing mute as to the charge.
Defendant never waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
17th at 1:30 PM with Judge Slay.
July 17, 2025, 1:30, Judge Slay.
And just to put on the record, my client just wanted to let the court know that he does currently reside in Colorado for his court date. I believe July 17th should be enough time, but he also is the sole caretaker of his 13-year-old child. So I believe July 17th should be enough time for him to figure out his court date.
All right, bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Your client's not here yet?
He did answer, and he said he's logging in.
An iPhone that logged in is, there he is. Court recalls the case People versus Clyde Moore Jr.
Assistant Attorney General Clarissa Williams on behalf of the people.
And this is the public defender, Madam Chair, I can rule, Your Honor, on behalf of Mr. Clyde Moore Jr. Mr. Clyde, say your name for the record, please.
Clyde Moore Jr.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of disorderly conduct, 90-day misdemeanor. Upon the successful plea to that charge, count one would be dismissed. That's the court's full understanding of the.
That is our understanding as well, Judge.
Yes, Your Honor.
All right. Mr. Moore, can you raise your right hand, please? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name for the record.
Clyde Moore Jr.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of disorderly conduct. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes, sir.
All right. Understanding all of that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You gave your attorney permission to sign your advice of rights form. Did they go through it with you?
Yes, sir.
Do you have any questions regarding any of those rights?
No, sir.
Paragraph 5 indicates your trial rights. You understand that you're giving up those rights as well as other rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're indeed guilty of this offense?
Yes.
Between the dates of August 1st, 2022 and March 31st, 2023 at a location, I guess, in Washtenaw County.
Yes,
Would
sir.
you admit to the fact that by failing to pay your child support, you were committing disorderly conduct by failing to follow that order?
Yes, sir.
All right. Counsel, has the court complied with the court ruling, would it be proper to accept this defendant's plea?
Yes, Your Honor, on behalf of the people, yes.
Defense is satisfied as well.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be June 17th, 2025, 9 a.m. before Judge Valvo. Bond in this matter will continue. Thank you.
Give you a
Thank
call
you,
in a
Your
minute, Mr. Moore. Thank
All
you,
right,
Judge.
I think, Madam Attorney, that's it for you, right?
It is.
Okay,
Thank
we
you.
got to it. You'll get to lunch. All right.
Thank you.
Thank you. You have a
Bye.
good day.
You too.
Court calls the case, People versus Keith Jimenez.
Ellie Zinn on behalf of the people, Your Honor. Kathleen Taylor on behalf of Mr. Jimenez, when you do get to the lectern, state your name for the court.
Thank you. Thank you.
Your Honor, at this time, we would ask the court to set a preliminary exam.
All discovery is complete.
Yes, Your Honor.
Would the people have their witnesses available to 10? Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Elton Bell.
Mr. Lonnie for the people.
Public Defender Kevin Dudish on behalf of Mr. Bell, please state your name for the record.
Elton Robert Bell. Yeah.
Your Honor, we were going to be requesting a brief adjournment so Mr. Bell can come up with more restitution.
Okay, how far off is he? I mean, I don't want to.
I get $50. I get $50 right now.
Okay, a month would be good, Your Honor, but whatever your Honor thinks is best.
Whatever I think is best.
We can request all we want, but it's
That's true.
Your Honor.
You're absolutely right.
best.
Am I here? All right. Probable cause conference without objection will be adjourned July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case People versus Stephen Johnston.
Maybe original.
Okay, I'm gonna put a tether on him. Where's Bukovich? He has not been up here for any case I've called of his.
Yes. Sorry. Assistant Public Defender Nicholas Buckovich on behalf of Mr. Johnston.
Your name, sir?
Stephen Johnston, Your Honor.
Thank you. What are we doing?
We'll be requesting a brief adjournment to pursue some negotiations. He also has some matters in the circuit court that we want to possibly reconcile together.
No objection to the adjournment. I did want to approach regarding a bond concern with Mr. Buckovich and with Ms. Linda, if you could, please.
With Ms. Zenda?
Yes.
Oh, dear God, come on. All right, record should reflect we've had a brief bench conference in this case. What I'm gonna do is I'm gonna move this PCC clock. There's information that's gonna be supplied to defense counsel that could affect the defendant's bond and the conditions on his bond. So I want to make sure we have at least some time to look at that information. So I'll pass this until 3 p.m. Thank you.
Awesome.
Court does call the case, People versus Rhea Brand.
And then on behalf of the people, Your Honor. Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Ms. Brand. Ms. Brand, if you could state your name for the record.
Zaria Brand.
Tell her to state her name for the record before I even ruled on her motion.
And what she just did? You did that?
Just go with the flow.
So she thinks she's all grown up now. Is that it? It's like between last week and this week that Tiger earned all those stripes. Okay.
Your Honor, we are requesting, I'm sorry.
She just doesn't care. She doesn't care that I've not done anything. Haven't given her permission. She's just gonna go. Don't worry about it. You're okay. It's her. I'm having an issue with her. I should make her do it all over again. That's what I used to do in the old days. But I'm a much nicer person now. I want so much to deny him. But I won't. Permission to practice is granted.
Thank you, Your Honor. I appreciate it so much.
Your Honor, we are requesting an adjournment in Ms. Brandt's case. We are still waiting on some video and a 911 call discovery, so.
Conference will be adjourned June 12th, 2025, 9 a.m. Bond will continue. Thank you, ma'am.
Thank you so much, Your Honor.
Court calls case, People versus Chad Jones.
Douglas for the people, Your Honor.
Herman Dadush on behalf of Mr. Jones.
Thank you.
Your Honor, we are going to be requesting an adjournment. He has two other PCCs up next week, where the bond, he was up last week.
Right.
We had adjourned those to next week. So I was going to adjourn to resolve everything together next week.
Oh, okay. So he was up. I adjourned those 2 weeks out, basically, so they landed next week.
Right.
And then there's this one.
Mhm.
All right.
And also we just got discovery on this case, so we need time to review it as well.
So everything right now is set for the 5th or the 12th for him?
It should be the 5th.
The 5th?
Yes, Your Honor.
Okay. And I'll adjourn his probable cause here to June 5th, 2025, 9 a.m. Get all his cases together. Bond will continue. All right. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case of the People versus Grace Brenner.
And then on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Grace Brenner. Will you state your name for the record?
Hello again, Your Honor. My name is Grace Brenner.
Thank you.
And Your Honor, we are
I
asking,
couldn't hear it.
she's fully capable. There's no reason, other than Ms. Brenner and I have been working together for a little while. No,
Kara wasn't supposed to do it? Oh,
I only have two. She has the other 10.
I thought she was trying to be late.
Yeah,
Okay.
no.
Okay.
I just took two.
All right.
The rest are hers. Your Honor, we're asking for an adjournment. There's some additional discovery investigation that we are doing in this
That's
matter.
trying to do on this.
Yeah.
Will 2 weeks be enough for you? Did you need more time than that? I know you're trying
Is
to.
2 weeks enough, Ms. Brenner, or do you need for the phone situation or would?
My apologies.
Sorry, go ahead.
I believe 2 weeks should be enough.
Yes.
Why don't I do this? Let me give a little bit more time. I'll just go to the 17th. That's a Tuesday.
Okay.
June 17th, 2025, 9 a.m. Bond will continue. Okay, thank you, ma'am.
Thank you, Your Honor.
Case of the People versus Bruce Pickens.
Andrew Childers appearing on behalf of the people.
Michael Getty, Assistant Public Defender on behalf of Mr. Pickens. Mr. Pickens, state your name. Bruce Pickens.
Thank you.
Your Honor, I'd ask the court to set these matters for exam.
For exam.
Yes, Judge.
All discoveries complete on this?
Yes, Judge, I believe so.
People have witnesses available to 10?
That's fine.
Preliminary examination in these matters will be set in person, June 10th, 2025, 9 a.m. before Judge Valvo. Bond will continue in these matters.
Thank you, Judge.
Let's call the case of People versus Frank Clark.
Michael Getty, Assistant Public Defender on behalf of Mr. Clark, Your Honor.
Mr. Clark, you'll have to unmute and turn your camera on. State your name.
Frank Clark.
All right, what are we doing?
Your Honor, I have had a chance to discuss this matter with the assistant prosecutor. I do believe we have a resolution. I'll need to go over that with Mr. Clark, and we'll need to do a plea form. I have submitted a adjournment request, but I think we'll be able to move this file next, at the next.
I have a green sheet.
I did submit a green sheet.
June 12th, 2025, 9 a.m.
Thank you.
Oh, you have a bunch of, okay, that's fine. On continue. Thank you.
Thank you.
I'll give you a call when I'm out of court, Mr. Clark.
Okay, thank you, Mr. Getty.
Look at your text.
Court does call the case of People versus LaDonta Skinner.
Okay, we're to make that for the people.
Good morning again, Your Honor. June Attorney Kara Rosengren, under the supervision of Assistant Public Defender Anna Happel, if it pleases the court.
Did I ask for all that? Did I ask for that? No. Yeah. She yells from way back there. So. Something Apple taught her. So, I can figure. Okay, go ahead.
Could you state your name for the record?
LaDonta Skinner. Thank you, Miss. All right, what are we doing?
We are requesting to adjourn for Mr. Skinner because we are attempting to look into some additional video discovery.
A lot of attempts to do things. Without objection, probable cause conference will be adjourned June 12th, 2025, 9 a.m. On continue.
Thank you, Your Honor.
Thank you, Mr. Skinner. Court calls the case of the People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton, who is appearing. All right, Mr. Clifton, could you please state your name for the record?
Deshaun Clifton.
Thank you.
And Your Honor, we're going to ask for a 2-week adjournment of this. We're looking for mitigation. Please.
June 12th, 9 a.m. On continue.
Thank you so much, Your Honor.
We're just moving the whole docket to that day. Court calls the case People versus Kevin Smith.
Okay, we're to make that for the people.
Stephanie Cannon, on behalf of Mr. Smith, who is not present, Your Honor.
No.
So, Your Honor, it's my understanding that he was being held. When I went, he was not. When I went to the jail yesterday.
Had a lot of that today.
And when I checked with him today, he wasn't there. So I have not had the opportunity to speak with him, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you so much, Your Honor.
Thank you. Court calls case People versus Duante Cooper Walker.
That is for the people.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cooper Walker, who should be appearing via Zoom.
Sir, please state your name.
Duante Cooper Walker.
Thank you.
Who should be requesting 2-week adjournment to obtain a media discovery.
Probable cause conference will be adjourned June 12, 2025, 9 a.m. Bond continue.
My client would actually like me to briefly address bond if possible.
Sure.
Mr. Cooper Walker is currently on a home confinement tether. He'd be requesting that his tether be transition from home confinement to GPS tracking. He is a father to 3 young children. He does want to participate in activities such as taking them to school and taking them to the park. He also is working at an employment. However, he has not been able to schedule the interview due to the home confinement tether. And as he did not have that prior to the home confinement tether being put on him, he couldn't constitute that as work. So we'd be requesting a modification of the GPS tether, the home confinement tether to GPS.
Your Honor, the people believe that home confinement is tether is appropriate here. Mr. Cooper Walker has an extensive criminal history. We would note that his criminal history is over the last few years. He has had 2 different HIDA CCW cases and a possession of analog HIDA case just in 2021. He had in 2022, he had a CCW and delivery manufacturing case. In 2024, he had an attempt R&O case, and then playing court and driver's license suspended case. The reason that he was getting arrested that led to this alleged R&O in this case is because he had a probation violation and a failure to appear in the 2 different 2024 cases. And when the police went to arrest him, he allegedly, even though he was at a baseball field filled with children, fled from the police, even though they tried to convince him not to create a scene in front of all the kids. The police had to chase him in between baseball fields where children were playing. So, Your Honor, we do believe that given all of this, he's both a flight risk and a danger to the public, and that the court can best protect the public and ensure that he appears as opposed to living in home confinement.
Anything else?
I was reiterate that he is a local resident of the county. He's been at the same address for the last 2 to 3 years. I do not believe he is a flight risk, and I do believe the GPS header would allow for insurance that he appears for court and allows the court to know where he is at. So I believe that would address any potential danger to the community.
Motion for bond reduction or modification is denied. Bond will continue as is. Calls case People versus Braylon Tabor.
Jennifer Douglas for the people.
Oh, she's back. Oh, she's not yelling from the back yet, though. She like waited to get all the way up here.
Hello again, Your Honor. Student Attorney Kara Rosengren, under the supervision of Assistant Public Defender Hannah Apple, on behalf of Mr. Tabor, could you state your name for the record, please?
Braylon Tabor. Thank you. All right, what are we doing?
We would request that the court set a date for exam, please.
All discovery complete.
Yes, sir.
People have their witnesses available to 10. Preliminary examination, June 10th, 2025, 9 a.m. That is before Judge Barr.
I'm sorry, apparently, Your Honor, Mr. Tabor already has court on June 10th. I'm sorry, I just found out.
Where?
It's a different case. I mean, it's a different state, but it's on Zoom, but it's a lot. I gotta do a lot that day.
So you can't do a Zoom here and have his preliminary exam?
I mean, I got stuff. I mean, it'd be better if it was a different day, basically.
Court would be so kind to set it for the next date after that. Otherwise, Mr. Tabor and I will work out the details.
June 10th better than 11 for. So.
Pardon?
It would be a week after that.
Oh,
Around
week.
Tuesday.
Okay.
Yeah.
Any objection from the people?
No, there's not an objection.
June 17th, 2025, 9 a.m. before Judge Moore.
Appreciate it.
Thank you so much, Your Honor.
Bond will continue. Thank you. Here to coordinate with people's social schedules. Huh? Yeah, Zoom meetings are social schedule, social thing. Yeah, I don't know. I shouldn't have done it. What? I don't have to do anything nice for the rest of the day? All right, that works. Court calls case, People versus Anthony Turner.
Children's attorney on behalf of the people.
Stephanie Canna on behalf of Mr. Turner. Your Honor, we are requesting a 2-week adjournment in this matter, and when appropriate, I would ask the court if I could address bond.
Without objection, probable cause conference, June 12, 2025, 9 a.m. As to bond.
Thank you, Your Honor. My client, he wants to let the court know that he's very apologetic for not appearing in court, for his failure to appear. My client is homeless, and so at that point, it was winter. The date, no mail, he wasn't receiving anything. And so he was picked up and subsequently arrested. My client is asking this court to allow him to be released today on personal recognizance. He is now back at the Delana Center and he's receiving his mail there. He has set that up. He is also receiving his shot now. So things are going a lot better for him. And so he's asking the court for the opportunity to be released.
All right, I mean, we waited a long time for him to be here, and I have no assurances that it's gonna show back up. So for those reasons, motion for bond reduction is denied, bond will continue.
I'm not going.
No, he's not late. We discussed that yesterday.
June 12th?
Yes, and I'll come see you before then, okay?
Court calls the case, People versus Sean Cotton.
Okay, Richard McDuffie.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cotton.
Sure, it's fine. You were here when I called you one of your cases. I'm shocked. All right.
Yes.
Mr. Cotton, can you state your name, please?
Yes, sir. Sean Cotton.
Thank you. What are we doing?
We'll be requesting adjournment to allow Mr. Cotton some time to pay some restitution towards a misdemeanor resolution.
Okay, how much more time is he gonna need to do that?
I understand he can make roughly $1,000 payment by next Tuesday. The restitution amount is quite substantial, so I'd be asking for approximately a month if possible to allow him to have a little bit more time. But he is supposed to be making a substantial payment by next Tuesday, or this upcoming Tuesday.
Any objection from the people? Turn it to July 3rd, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Martez Dalton.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Dalton. Your Honor, but not with him. I did receive information this morning that he contacted Mr. Bowling from our office and that he is on a bus from Detroit and was en route this morning.
No.
I think this happened last time.
Like 3 or 4 weeks in a row of a bus story. No.
I think I might have missed those dates, but it sounds like he appeared eventually.
I can tell you the attorneys in your office to talk to about the bus thing. So where is he right now? Because Cannon was involved with the bus. She's the one that had the picture.
I'm like, why?
Video.
If I would have known, I would have submitted a Zoom.
So what?
In suits.
I know. I had no idea of all of this. Or
Who's innocent? No, Apple, no. So where he's coming from, a bus from Detroit? That's where it always starts. So what do you want me to do?
If the court would be so gracious to pass this matter.
Okay, so the first one I passed was at 9 o'clock. We called him what? At 3 by the time he got here. The other one didn't get called till late afternoon. You have no idea where, do you really have any idea if he's on a bus?
My understanding is he's talked to Mr. Bowling this morning and was on a bus en route.
So Bowling's the one that's telling us.
Yes, I have not had direct. I have no reason not.
All right, then I need video. I'll pass it.
Maybe I can get a photo.
Video other than like out the window seeing trees go by. I need.
All right, I'll try to do that. Thank you.
We're not getting video. Court calls the case, People versus Thomas Vasher.
Ashley Lonnie for the people.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Vasher.
Your name?
Thomas Basher.
All right, what are we doing?
Your Honor, we are requesting an adjournment to obtain some media discovery, and when appropriate, my client would like me to address bonds.
He has a bond. Hey, do you have the bond violation report?
I do not have the bond violation report.
This just came in.
Oh, then if it just came in, I would not.
A bond violation.
I don't know.
It's a report that was you.
Oh, you know.
Oh, that's my handwriting.
know.
Yeah, unless if-
Oh,
I don't,
You didn't remember?
yeah, that might be why he's in custody.
Right. That
Got it. Okay, got it. All right. Probable cause conference, June 2025, 9 a.m. As to bond.
as to bond, Your Honor, I'll be requesting a PR bond on behalf of Mr. Vasher for the reason why he missed his last probable cause conference court date. It did appear he was in communication with our office. He did talk to one of my colleagues. They were going to request an adjournment, and he misunderstood, thinking that meant he would, that mean that he didn't have to show up to that particular court date. So we do have good contact information for him. He is being supported by his church and has been attending programming from Home and New Vision. So I would be requesting a PR bond.
You sponsoring the people?
Your Honor, I do believe the defendant is on probation under the 22nd Circuit Court for assaulting, resisting, or obstructing a police officer. In this case, he was taken into custody, I believe, for a warrant related to that probation. And when he was arrested, he was found to be in possession of several different individuals' IDs or cards, or credit cards of this nature. So I do not think a PR bond is appropriate, and he did have a failure to appear.
Anything else?
I said, I was reiterate, I know he has a support system. He will be appearing in the court. We do have good contact information for him, and I will be requesting that.
What do you want to say, Mr. Vash?
Mr. Simpson, Your Honorable Judge, I just want to inform you that every day of my life, I get up and I live with that lady in the back there in the court, and I get on my bicycle and I ride right there, the little lady right there. And I ride my bicycle every day, and I pick up garbage out of churches and school parking lots. And that's where I find
I would
IDs,
advise
credit
you
cards.
stop making any statements, because those could be used
Well,
against.
that's just the truth. That's where I even got the credit card.
I would advise you stop making that statement.
I've done everything right. I'm doing good. I'm really, for the first time in my life, proud of myself.
I've set this out to the 12th. I'm going to deny the request for a change in bond at this juncture. Is he going to be dealing with the circuit court matter anytime soon? Violation?
I'm not sure of his court date off the top of my head. I would have to check.
Okay. So his bond at this point will continue. Thank you.
So PR bond?
Your bond's continued. It's not a PR bond.
It's not a PR bond?
Your bond's being continued.
I've been doing everything right, Simpson. Everything. Everything I'm supposed to.
Okay, you keep talking at me, it's going to get worse. Okay, thank you. Cross case, People versus Dave Ellington. Oh, no. Oh, no, she's back. No, I didn't mean that you couldn't yell from the back. I mean, you can yell. Everybody else yells.
Student attorney Kara Rosengren, under the supervision of Assistant Public Defender Hannah Apple, on behalf of Mr. Ellington. If you could state your name for the record.
Dave Ellington.
Thank you, sir.
You're welcome.
All right, what are we doing?
Your Honor, we are asking for an adjournment so that we can review the discovery that we have with Mr. Ellington.
All right. Probable cause conference, I'll adjourn it to June 17th, 2025, 9 a.m. Continued. That's a Tuesday.
Okay. Thank you very much, Your Honor.
Thank you.
Thank you.
Thank you, sir. Yes, I did. Court calls case People versus Brittany Weatherspoon.
And then on behalf of the people, Your Honor,
We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Brittany Weatherspoon. Ms. Weatherspoon, please state your name for the record.
Brittany Weatherspoon.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination at the earliest possible date.
Discovery is complete.
As to the best of our knowledge, we have everything there is to have.
People have the witnesses available the 10th. Preliminary examination in person, June 10th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you, Bond. Continue. Sure.
It's come to my attention that she has attempted to call the victim 3 times after she was arraigned. So this time I would be asking that her phone would just be revoked, given that she has no contact in this case, as well as her case in district court with the same victim.
Your Honor, is there a no contact provision in this case?
Is there one?
Yes. My client understood that due to the pregnancy between herself and the complaining witness, that she was allowed to have some contact to discuss that.
I have in my notes that it would be third party contact, not contact directly with the victim.
What I have, it's no contact with Mr. Chandler. And then under other conditions, third-party consensual contact allowed for pregnancy update.
Okay, so I believe my client may simply have misunderstood.
Yes, Your Honor, I apologize. I misunderstood that. No way, shape, or form.
So she wasn't intending to violate any of the bond conditions. So I think she just misunderstood what kind of contact you have with respect to the pregnancy. So we'd ask that going forward with an admonishment from the court that she knows that she's not to have any direct contact, that her phone privilege is allowed to be remained because she'll still need to contact other people concerning the pregnancy.
So I guess I'm trying to figure out, how was the third party? I mean, that's said here, but I don't know how that was supposed to work. So, I mean, I might.
I'm not
Ms.
sure neither.
Weatherspoon might be confused. Ms. Weatherspoon, sometimes when you're winning, you should probably just be quiet. So how is that supposed to work? I'm trying to figure out what it means so I can even apprise Ms. Weatherspoon what it means. Is that? Sure. Record to reflect you had a bench conference in the case, and I just wanted, so it's clear on record, based upon what was done, that there's a PR bond actually in this case.
There is.
She may be held on something else. Yes. Ms. Weatherspoon, your calls to Mr. Chandler, and I'm not going to change the way that this is, but I need you to understand what it means. If you have to communicate something to Mr. Chandler regarding your pregnancy, and only for those reasons, you have to do that through a third party. So you got to call somebody else, and it's only regarding your pregnancy update.
Yes, Your Honor.
All right. So you have to call somebody else to then get that information to.
Yes, Your Honor.
Okay. All right.
Thank you.
Thank you for bond.
I think for the record, my client has made it clear that she does not want me to address the bond in this case other than.
Yes. Okay. Very good. Thank you.
Thank you, Your Honor.
Thank you, Ms. Lewis. Go ahead, Bob.
Do you want my work?
No, I did, but
All so our last 2 custodies meet as parents. So you're all out until we get to the Spanish.
I'm all out of any custody. Court does call the case, People versus John Fleming.
Good morning, Your Honor. After my stronger, permission to appear.
Who? Hold it.
Your Honor.
Nice water?
Longer.
Longer. Nice longer? Go ahead.
Requesting permission to appear pursuant to MCR 8.120 under the supervision of APA G. Kennedy.
You've not appeared before me.
I'm not.
Have you appeared before me before?
Well, it's my first time.
Really?
Yep, I did appear for, Judge Washington.
I don't care. Did I ask that? Do you think she called me and said, wow, that attorney was? No. All right, where are you from?
I'm from Michigan.
The whole state?
Well, right now I'm in Wisconsin for law school. Oh, I'm from the southwest part.
Follow my question. Where are you originally from?
Originally from Centerville, Michigan, in southwest.
Okay, I know. I can go under a rock and I don't even look at a map. Okay, so you're from Michigan. You're in, where'd you go to undergrad?
The University of Michigan in Ann Arbor.
Sorry. Then you left there and now you're in Wisconsin in law school.
Yep.
So now you're a Badger.
Go Badgers.
Oh. They tell you nothing in orientation.
They told me to be very respectful.
Go Badgers, go blue. She's failing. Okay, permission to practice is granted. Welcome aboard.
Have a nice one.
All right. Oh, no. Other, go for it.
Good morning, Your Honor. Andrea Sabri requesting permission to practice.
Are you reading?
Pursuant to Michigan Court Rule 8.
Are you reading? Are you reading that statement?
No. I have it
No?
memorized.
You have it memorized? Why were you looking at your computer?
Just to make sure I got every word.
Are you nervous?
No.
No?
No.
Go ahead, I'll let you finish.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinrulu, representing Mr. John Fleming,
You
who is
appeared
present.
before me before, didn't you?
I have.
Yeah.
Yes.
How'd that go?
It went well.
Did it?
Yes.
Oh. Oh, I recall that. Anyway, go ahead. Permission to practice is great.
Thank you.
Sir, what's your name?
John Fleming.
Thank you for your patience. All right, what are we doing, folks?
Your Honor, we respectfully request that this matter be set for preliminary exam.
All discovery is complete.
To my knowledge, Your Honor.
She's all in that computer. I don't know what's in there, but. Would the people have their witnesses available to 10? Hello? Don't help her out. Jeez, oh Pete, I don't know. Where'd you go for that moment? Did you see her? I asked the question. She went. Preliminary examination in person will be set June 10th, 2025, 9 a.m. That is before Judge Balvo.
Thank you, Your Honor.
You are welcome. And are you going to do the exam? Oh, because I was going to say, make sure that you tell Judge Balvo that you've been before Judge Washington and me. All right? She won't care, but go ahead. All right, thank you.
Thank you.
She's not going to want to come back up. Court calls the case, People versus Jamie Good.
Testimony for the people.
Edma Dadush, on behalf of Ms. Good, who is approaching. Can you see your name for the record? please? Jamie Good.
How are you, Ms. Good?
Good. Are going to be waiving the preliminary examination.
Is that correct, Ms. Good?
Yes.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court
Yes.
for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination haven't been waived, defendants bound over to circuit court on the single count.
Your Honor, we waive formal reading and stand mute.
Then in every way, formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th, 1:30.
July 28th, 2025, 1:30. Judge Hamud.
Thank you, Your Honor.
Court calls case People versus Tijane Gray.
Christina Bear-Guerin for the people.
Again. Back.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Gray, Judge.
All right, yes, he's here. Sir, state your name.
Dijon Gray.
Thank you. You're requesting an adjournment.
Yes, Your Honor. I did have a chance to speak to his attorney in the other count in Wayne County. I think there's a competency evaluation that's set for July 25th.
Competency in Wayne County?
Yes.
Do they know what's the timing on that? I'm having a problem. I mean, if we proceed.
Yes, that's why I was, I believe the competency hearing in Wayne is July 25th.
July 25th, you said?
Yes.
I guess then it would make. Why my calendar run out of dates? August 1st. Hold on a second. Why? Yes, it is. Thank you. I see that. All right. Then I'll adjourn the probable cause to July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. I'll be in touch, Mr. Gray.
Okay, thanks.
Case People versus Latosha Griffin.
Ms. Griffin, who is approaching.
Hello.
Hi. Your name for the record.
Latasha Griffin.
Thank you. What are we doing?
Your Honor, we are going to be requesting an adjournment. Yes.
Any objection from the people?
I don't know what the adjournment is for.
I have no idea either.
My client is in the process of getting a job and she wants to share that with the prosecution pursuant any potential plea negotiations.
Got it. Okay.
I just revoked the offer, so.
Pardon?
I said I just revoked the offer. So.
You did?
Yes.
Yesterday?
Yes, Your Honor.
Council approach. Hey, record should reflect you had a conference in this case. And probable cause conference will be adjourned June 17th. That's a Tuesday, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court calls case People versus Demetrius Griggs.
And Lizette, on behalf of Your Honor.
Stephanie Cannon on behalf of Ms. Griggs.
Ms. Griggs.
And Your Honor, in this case, we are going to request a 2-week adjournment. We're missing discovery. I did email about it last night. I've not received confirmation that anything has been returned or given to us, but.
Your Honor, I did request a 911 call yesterday. I believe the media is in the file. It should be over to your office.
Probable cause conference will be adjourned June 17th, 2025, 9 a.m. Bond continue. Thank you.
So we.
Court calls case People versus Arlisha Henderson.
Thank you, Rachel, for the people.
No, sir. No, sir.
Good morning, Your Honor. Student Attorney Audra Sabri on behalf of Arlisha Henderson, who is present today. Please state for the record.
Arlen Henderson.
Thank you.
Sorry, Your Honor. Your Honor, we respectfully request an adjournment to explore restorative justice options.
To explore what?
Restorative justice options.
Who sent you up here to say that? Tanasa did that, did why? Go ahead. They throw you under the bus in a minute. So go ahead and throw them under the bus. I won't do anything to you.
It was a team effort, Your Honor. We looked at all of our options for our client.
It was a team effort. Probable cause conference, June 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
It was a team effort. You'll learn soon enough to throw Chinaz under the bus. Court calls the case, People versus Timothy Hutchinson.
We're ready in that matter, Your Honor.
Alexander on behalf of the people, Your Honor.
On ground.
Public defender with and on behalf of Mr. Hutchinson, who approaches the podium. Mr. Hutchinson, please. Record.
Timothy Hutchinson.
Thank you. All right, what do we do?
Your Honor, today is the date and time set for the probable cause conference. My client wishes to have this matter set for preliminary examination at the earliest possible.
I'm sorry?
At the earliest possible date.
Okay. Discovery is complete.
It is to the best of our knowledge.
Preliminary examination will be set June 10th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Marcus Jones.
And today.
What was that? What? Mr. Brown has an office at the podium. This is Buckham.
I'm stalling.
What?
I was here for this one, Your Honor. My client wasn't.
No, you were here and then you turned your back on me and started walking out talking. I don't know what you were saying.
Mr. Jones was here, maybe pass this to one for a second.
You lost a client, Buckovich? You have no idea, do you?
Some people have, he might have needed a restroom break, Your Honor.
Find him. I'm gonna take one of the two of them in custody. Huh? So this is the next one. Okay. This is in a way. Got it. I see what you're saying. Got it. Court does call the cases of the People versus Quincy Jones.
Hey, Rachel McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones. All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you're charged with?
Okay.
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
For what?
Mr. Allen. Mr. Jones, what's gonna be in your system? Because I can't arraign you if you're under the influence of something. So you might as well just tell me.
Some marijuana.
And what else?
Probably a little bit of cocaine.
Probably a bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay, so when did you take the cocaine?
About 2 or 3 days ago, so it ain't on my system.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something, you're on something right now. What are you on? What
do you mean? Like,
the worst thing is to lie to me.
What do you mean? What do you mean like on something? Like, what do you mean? Like, did I do something to get today or?
I don't think that's really a hard question.
Oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bonds revoked, defendants remain.
Thank you, Governor. I.
Why? Good, that works. And I'm gonna set that for the fifth.
Yeah, I gotta mark it up.
Good job, Denise.
I was asking, has this case recalled because he would like to address the issue of bond?
Who?
Mr. Warren Brown?
Why? What's the issue of bond?
No, he wants to address an issue of bond.
Client here? Yes. He wants me to lock him up?
Probably not.
Can you see I'm busy? I'm waiting for the bus people.
Correct.
Where's? Oh, recall it. Court recalls the case of People versus Timothy Hutchinson.
I'm ready, Your Honor. I apologize. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Hutchinson. I apologize. There was an issue that Mr. Hutchinson had asked me to address. He has a CDL. He drives interstate and in Michigan to deliver. So he's asking that his bond be modified to allow him to be able to do that for the purposes of employment.
Said he has a CPL?
CDL.
CDL, okay, I was gonna say. So he just wants to be able to.
To work, to be able to drive.
But he drives intrastate, he drives Michigan only, right?
And interstate, both.
Is there something that's prohibiting him from doing that?
Not that he's aware, but he wanted to make sure that he did not do anything that went against his bond.
I have nothing that restricts him being able to go anywhere in Michigan, so you.
Well, he drives interstate as well, so he needs to be able to go.
Well, if he's leaving, so are you leaving the state of Michigan when you're working?
For your work?
As of right now, for my current job, no. The prospective employer I'm considering working for, yes, I would be required to drive interstate between different states. And I was told that I could not leave the state of Michigan.
Correct.
If that does change, I will be able to in order to get that.
Okay. Then we can get it changed. That's, if your job changes, then certainly we can do that. But right now you can, as long as you stay in the state, you can go all over. Okay?
So go ahead.
Thank you.
Okay, all right, thank you.
Everything on my left is spent. Okay, so we can do those in a moment. I have Jones and Dalton. But Jones, that was Buckovich running around. Did you find your client?
No, Your Honor. Yes, I checked the rest of it. Yeah, I did speak.
Just leave?
I did speak to my client this morning. I knew he had an appointment to go for begin outpatient treatment today. He told me it was either at 12 p.m. or 2 p.m. He did not remember the exact time. But I did speak to him this morning and get updated contact information from him. So I did try to give him a call and a text, but I haven't got a reply. But he was here this morning.
Oh, thank you for chipping in, Janaza. Everybody was doing just fine. I don't know why did you feel compelled to say anything? Like he told me like 8 times he's been here. Why'd you? Do you know where he is? Then why are you talking? So do you think he's gonna show up or not?
I reached out to him, but I still don't have a reply at this moment. So, but he was, like I said, he was here this morning, so I can try again, but I can't make any guarantees.
So what do you want me to do?
Well, I was gonna request adjournment.
Well, that's not happening. I need him here. So what else do you want me to do?
Can you pass the matter?
Sure. That was for dramatic. Yes, I'll pass.
Thank you, Your Honor.
Well, I don't know because this is Apple's mess.
14A District Court for County of Washington, I'll say the district is now in the Honorable Judge Simpsons.
May be seated. Court does call the case, People versus Martez Dalton.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Dalton. Please state your name for the record.
Martez Dalton. Thank you, Your Honor, once again for passing up on the matter, sir. I was having a very difficult time getting here today, but I made no excuses. I'm here, Your Honor.
I told you he was gonna be here.
That is not what she said. I had all the faith in the world that you were gonna be. So I'm glad you made it.
And yes, Your Honor. And to be honest, Your Honor, I only need like 2 more weeks to get my license, so this won't even be a problem anymore. I've been working hard as I possibly can to get this license, Your Honor.
Okay, all right. All right, what are we doing?
We are asking that this matter be set for a preliminary exam.
You have all the discovery.
Correct.
People have their witnesses available on the 10th. Preliminary exam, June 10th, 2025, 9 a.m. in person.
9, sir.
9
9.
That one you can't, that one you cannot be late
I will
to.
not be
Yeah.
late. I don't care what's going on. Hell, high water, whatever. I'm gonna be here, Your Honor.
That's what you told me the last time.
I promise listen, I broke ass to get here.
Said, I'm gonna get here. I'm gonna do everything.
But last time the D2, A2
Here I
stopped running.
am. Here I am at 1 o'clock
I am
for a
though.
9 o'clock call on your case.
I am getting my license in 2 weeks.
Your Honor, if the court may consider bumping it out a week, it sounds, or a week after that, if he's gonna have his license, and that way there'll be no issues regarding transportation.
0. Not even trying to play with the court's time, Your Honor. And I appreciate you all for being as patient as you have been. Thank you.
Yeah, that's my middle name. Patience. When are you getting your license?
I have 1 more court date, which is Taylor on next week, Thursday, a week from today. And then I'll paying everything off. I've already paid off quite a bit of money to Warren and Detroit and Canton. You all are coming up in a few days.
So we had to wait behind all those people and wait for you today?
It's just about the court dates, the way they was all.
Oh,
Your Honor, that's all. I can only take care of them when they come
Okay,
up,
all
Your Honor.
Nice try. All right, I'll move it out to the 17th. If there's no objection from the people.
No objection.
June 17th, 2025, 9 a.m. That's before. Oh, man.
At noon?
Okay, it's at 12 noon.
Yes, sir.
Before me. I dare you to be late.
Oh, no, sir. No, sir.
I double dare you.
Make it 11:30.
So I'll be here at 10 in the lobby.
Thank you, Judge.
Thank you.
Time continues. You're welcome. Court calls case, People versus Jamie Foxx.
Ashley Lonnie for the people, both matters.
Ellis Freeman for Jamie Foxx, along with Mike Gaddy. Jamie's right here.
Mike Gaddy, Assistant Public Defender on 25F 20223.
All right. And what are we doing here?
Your Honor, we're asking for an adjournment of this matter. There are some records that we need to get in order to explore filing a motion in this matter to be heard. That may be dispositive.
All right, that's on both of these.
Well, we're trying to keep them together, Your Honor.
Okay. So how much time are you looking at?
Yeah, maybe 3 weeks.
Either 17th or the 26th.
You know me, Judge, I'd prefer the 26th.
What'd you say?
I said, you know me, I'd prefer the 26th.
Just wanted you to say it out loud so I can pick the 17th. No. Probable cause conference, June 26th,
Thank you, Your Honor.
Thank you, Your Honor.
2025, 9/8.
Thank you, Your Honor.
You're welcome.
Right, I got the release. I want to give you a notice, okay?
Perfect testing,
What'd you say?
perfect testing.
Perfect testing. Keep it up.
Yes, sir.
Court calls case, People versus Anushka King.
Maybe it works in the good for the people.
I probably messed up that name, but that's okay.
Good afternoon, Your Honor. Student Attorney Kara Rosengren, under the supervision of APD Hannah Apple, on behalf of Ms. King, if you could state your name for the record, please.
Anushka King.
All right, what are we doing?
We're asking for an adjournment, Your Honor, so that Ms. King can pursue sobriety court options in Wayne County.
How much time is she gonna need to try to figure that? All really depends on what part of Wayne County.
Judge, we're looking into 36th district, so I haven't submitted a referral form yet, so maybe just a couple weeks to get a status check.
All right,
Something is in the works.
that's what you meant to say, is
Yeah, that's what she said.
okay. June 17th. That's a Tuesday, 2025, 9 a.m.
Birthday with 36.
Bond continues. All right, thank you.
I'm sorry, Your Honor, Ms. King just let me know that she has a court date on June 17th in that district in person.
In what district?
36th district.
All right, I'll go to the 26th. June 26th. 9 a.m.
Thank you, Your Honor.
Court calls case, People versus Nicole Knox.
Hello, Your Honor. Student Attorney Kara Rosengren, under the supervision of Assistant Public Defender Hannah Apple, on behalf of Ms. Knox.
Nicole
Please.
Knox.
Thank you.
Your Honor, we are still waiting on discovery for Ms. Knox, so we're asking for an adjournment.
What are we waiting? What?
Yeah, we don't have a police report or anything, so.
Is this the first PCC? Do you know if discovery's been sent?
I'm not aware of it. Your Honor.
Ashley Lonnie for the people, Your Honor.
And Judge, just so the record's clear, we did notice that earlier this week, our legal assistant reached out yesterday regarding following up on the discovery. Or waiting to hear that.
June 17th, 2025. 9 a.m. Bond continued.
Thank you.
It's great. Before Lonnie and Apple stepped in, it was looking at those two and their eyes got this big. And I started asking. Oscar just looked at me like, I don't know. And then stared at Lonnie. Court does call the case of the people versus Sheldon Lewis.
If you were speaking up for the people.
Okay. Yeah, no, we didn't.
Why are you involved? Why are you involved? Is it your case?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Lewis. State your name for the record.
Sheldon Lewis. Thank you, sir. Why does everybody just walk away? Buckovich did that now. Oh, she showed your green sheet.
Yes. Your Honor, we are asking for an adjournment. There is some outstanding video discovery that we've asked from YPD.
From where?
YPD.
Okay. Probable cause conference, June 17, 2025, 9 a.m. Bond will continue. That's a Tuesday, so. Okay. Okay. Thank you. Court does call the case, people versus Mikesha Melchor.
Good morning, Your Honor.
Assistant Public Defender Nick Buckovich on behalf of Ms. Melchor, who is appearing via Zoom. Ms. Melchor, can you please state your name?
Mikesha Melcher.
Melcher.
So at your time, Your Honor will be requesting an adjournment. Ms. Melcher is beginning inpatient treatment. We just need some time for her to begin that process so we can.
When is she beginning it?
She actually began her intake. She began her intake yesterday. So she's beginning treatment now. So we have some time for her to have some positive outcomes and for potential negotiations with the APA.
Yeah, this is my second phase.
Second day?
Yeah.
Second phase.
At second phase, she did some inpatient treatment. Now she's doing some intensive outpatient treatment.
All right, June 17, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Good luck to you, man.
Thank you.
Court calls the case, people versus Megan Moses.
Ashley Lonnie for the people.
Assistant Public Defender Nicholas Buckovich for Ms. Moses, who should be appearing via Zoom.
Ms. Moses?
Hello?
Hello, I need a camera, please.
Yep, just 1 second. I am indisposed. I gotta wash my hands. Sorry. I got great timing.
We'll wait.
I'm sorry. I was not trying this. I knew that would happen too. I'm almost done.
Okay.
My apologies.
Okay, can you state your name, please?
I'm Megan Moses. I'm coming.
Okay, well, hold on, that's not her. Something popped on, but. Okay, there you are. All right,
Hi.
okay. What are we doing? We're adjourning?
Yes, we'll be adjourning for some further negotiations and some more discussion with my client.
June 17, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Thank you, ma'am. Court calls the case, people versus Nicole Nelson, 2 cases.
Okay, Rachel McGinn for the people.
And Assistant Public Defender Chinonza Carey, Your Honor, on behalf of Nicole Nelson. He is on Zoom, Judge.
Hello, can you unmute and state your name, please?
Nicole Nelson.
Guess you need an adjournment.
Yes, Your Honor.
He has other cases you're trying to resolve with.
Yes,
this?
Your Honor. I think he was just sentenced in this court yesterday on, so we're trying to see how we can, and there are some 15th district matters as well.
Do we have timing on the 15th district court matters?
Those three trials are on June 4th.
Okay. So why don't I do this then? I'll adjourn these out to June 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
Your Honor.
June 17th.
Sir, thank you.
That's a Tuesday.
Thank you. Sorry.
All right. Bond continued. Thank you, sir.
Thank you.
Court calls the case, People versus Timothy Pennington.
Ashley Lonnie for the people.
Student Attorney Andra Sabri on behalf of Mr. Timothy Pennington, who is present in person, Your Honor. Please state your name for the record.
Timothy Pennington.
Thank you.
Your Honor, we are requesting an adjournment as we are waiting for media evidence.
2025.
June
9
12th.
a.m. Yes, the 12th. Bond continued. Thank you, sir.
Your Honor.
Court calls case, People versus Tyler Pittman.
Andrew Childers.
I'm at Adish on behalf of Mr. Pittman. Your name for the record?
Tyler Pittman.
Your Honor, we're going to be asking for one last brief adjournment. Mitigation has just been completed as of this morning. We just need a short adjournment, if Your Honor will grant that, to send that to prosecution and continue pleading.
Probable cause conference, June 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case, People versus Danielle Presley. Or Pressy, excuse me.
Andrew Childers appearing on behalf of the people.
Michael Getty, Assistant Public Defender for Ms. Pressy, who's here to my right, Judge.
Your name?
Danielle Pressy.
Requesting an adjournment for mitigation.
Yes, Your Honor.
Is that for the report or for?
She is, Ms. Pressy has had her initial meeting with our mitigation team. I believe there'll probably be one more and then we'll write the report.
All right, let's do it this way. Probable cause conference, June 26th, 2025, 9 a.m.
Thank you, Your Honor.
Continued. Thank you.
Cool.
Court calls case, People versus John Riggs.
Ashley Lonnie for the people.
Michael Getty, Assistant Public Defender on behalf of Mr. Riggs, who's here via Zoom, Judge.
Sir, state your name.
John Riggs.
All right.
Your Honor, we're asking for an adjournment in this matter. I have been in touch with the Assistant Prosecutor, Ms. Curry, who is with the Sobriety Court and Circuit Court, where Mr. Riggs is currently a participant. She's not closed off to him to a referral to that court for her to review. I'd ask the court to adjourn this matter so I can make that referral and see where that plays out.
June 12th, 2025, 9 a.m.
I mean, we heard on bond.
May.
Now, this is an OWI third offense. The facts include the defendant crashing his motorcycle. And then when he did have his blood drawn and went on police, blood alcohol was 0.238. He's currently on twice a day sober link, I believe. I would request that the court either put him on a scram tether or increase his testing 3 times a day.
When you respond.
Your Honor, he is being supervised right now by the sobriety court. If the court is going to modify the bond, I'd ask that the court increase the testing to 3 times a day on the sober link to allow him to do that. I don't think he's had.
How long has he been in sobriety court?
He was in sobriety court at the time of this offense.
Oh, he was.
Yes.
Okay. Okay, I would grant the people's request and just indicate that sir, you're currently on a sober link, correct?
Yes, sir.
All right, that sober link testing will increase to 3 times per day.
Yes, sir.
Thank you, Your Honor.
Your Honor, will he need
Gonna
to,
need a new order.
and, Your Honor, shall I have him contact community corrections to get the parameters of the daily testings?
Right. They will, he should contact them. We'll be sending over the order shortly. Then they'll give you your timeframes. All right.
Okay, sounds good, Your Honor.
All right.
All right. I would contact them around 3:30.
Okay, thank you.
All right.
Thank you, Judge.
Court does call the case, People versus Melton Rucker.
Provision of APA, Jake Kennedy.
On behalf of Mr. Rucker,
Oh,
state your name for the record.
No record?
I think he needs to.
Yes.
Oh, that Kennedy supervising people? Good Lord. Huh? Yeah, but that's 2 of you that don't know anything, so of course it's going well. No.
You guys hear better?
Sorry, throw that out there. All right. Can you hear me, sir?
Yes, sir.
All right, very good. State your name.
Milton Rucker.
Thank you. All right. And he's waiving.
Yes, Your Honor.
All right. Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing?
Yes.
You'll be proceeding to circuit court for further resolution.
Yes, sir.
All right. People also waive their right? Yes. Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts.
Your Honor, my client stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
July 17th at 1:30 PM with Judge Slay.
July 17, 2025, 1:30, Judge Slip. I'm sorry. That's the wrong judge.
Yeah. You should get your pitch complete on July 22nd.
July 22nd, 2025, 1:30 for Judge Cunt.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you.
Thank you, sir. Court does call the case, People versus Jody Ann Russell.
Thank you, Rachel McDuffie for the people.
Student Attorney Andra Sabri on behalf of Jody Ann Russell, who is present in person. Please state your name for the record.
Jody Ann Russell.
Thank you. All right.
Your Honor, we are respectfully requesting an adjournment as a referral has been made to the AIM Division for mitigation and negotiations with the people are ongoing.
No objection to the adjournment. I wanted to ask if we can approach with Carrie and Ruby as well to just address some bond concerns that may not be best placed on record.
All right. All right, court's gonna pass this matter and I'll come back and we'll address everything, okay?
Thank you, Your Honor.
Court calls case, People versus Renee Schummel. Or Schmel, excuse me. I was putting letters in there. I probably shouldn't have.
Student Attorney Kara Rosengren, under supervision of APD Hannah Apple, on behalf of Miss Renee Schmel. Can you say your name?
My name is Renee Shermel.
Schmel. Okay, got it.
Yes,
All right. Got it. I'll mess it up again, but.
I'm sure a lot of people do.
All right. All right, what are we doing?
We're requesting an exam date.
All discoveries complete.
Yes. Yes.
And would people have their witnesses available on the 10th? Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Barr.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Case of the people versus Jeremy Stoltz.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Schultz in both matters. Your Honor, it's to my knowledge that Mr. Schultz is currently in custody at Wayne County Jail. I found this out over the weekend and having communication with APA Douglas about that, but obviously there was not enough time to file a writ. I confirmed he was in custody on binding shortly before this afternoon block began. So I'd be asking for an adjournment to allow time for the writ to be filed.
June 17th, 2025.
And I do have green sheets for both cases, Your Honor.
All right, thank you. Court calls case people versus Derek Shipman.
Here to the deputy for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Shipman, who's approaching judge.
State your name.
Derek Shipman.
You're requesting an adjournment.
Yes, Your Honor, there's some video that we need to get a look at.
Probable cause conference will be adjourned June 12th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Elijah Stewart.
Stephanie Can on behalf of Mr. Stewart, who's approaching. Mr. Stewart, could you please state your name for the record?
Is Elijah Stewart?
And Your Honor, sorry, I didn't hear. We are going to ask that this be set for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 10th.
We'll do our best, Your Honor.
Preliminary examination in person will be set June 10th, 2025. 9 a.m. That is before Judge Valvo. Bond will continue. Thank you.
Thank you so much, Your Honor.
Thank you.
Court calls case people versus Rashawn Vincent.
Ashley Lonnie for the people.
This is public in Apple appearing on behalf of Mr. Vincent. He appearing via Zoom. I just talked to him. No? Oh.
Do we have him?
I do not have him.
Oh, he's probably on the bus.
No,
No,
he's not on the bus.
he's not on the
Green
bus.
screen,
Okay, I'm
none of that.
asking.
I just spoke with him on the break. The court would be so kind as to pass this matter.
Sure, Mrs. Bukovich. Court calls the case people versus Bobby Williams.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Bobby Williams, who approaches the podium.
Andrew Childers appearing on behalf of the people.
Please state your name for the record.
Bobby Williams. Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination at the first available date.
You have all the discovery.
Yes, Your Honor, we have a discovery request in. We expect to receive all video and any recorded information.
People have their witnesses available to 10.
Yes, Your Honor.
Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
June 10th.
Thank you.
At 5 a.m. I'm going
Court does call the case of the people versus Joel Jones.
Good afternoon, Your Honor. I'm the Burgess for Joel Jones.
You guys gotta let her through, please. Got it. Okay, I do not have Miss Webster Cox here. What's your name?
Joel Jones.
All right. Have you heard it all from Miss Webster Cox, Mr. Burgess?
No, Your Honor, I have not.
I called her office earlier. They had no idea what I was talking about, so I don't think that she knew that she was assigned.
So let me I want to make sure I'm understanding what you're telling me. You called her office.
Yeah.
When did you do that, today?
Yes, because I've been here since 8:30 this morning.
Right.
So I called her about, I say maybe 30 minutes ago when you went out into the break. And they had no idea she was assigned to this case.
Is this an assignment or is it?
But she was on. She was on the initial. She was, yes.
Was it an appointment
Yeah.
from MACA?
Then more steps.
Oh, that's why. Okay, so now that I look at this, so you were in warrant status since you said 2021?
Yes, and I went and turned myself in for all of my warrants on the 22nd.
Right, but she's not gonna get notification of it right away. She wouldn't get it through the normal channels. So, she's still attorney of record on the case. Okay. So we have to leave her. Mr. Burgess, what were you gonna do with your case?
Your Honor, I just got it yesterday. I was just assigned yesterday. I was asked for a 2-week adjournment of the probable cause conference.
Okay, so let's do this. All right, young lady, here's what I'm gonna do. I'm gonna adjourn your probable cause conference to June 17th, 2025, 9 a.m. That's a Tuesday.
Okay.
Okay. And what I'm gonna suggest you do is continue to contact Miss Webster Cox's office because she's still attorney of record.
Okay.
All right, in case. I think what's causing so that you know, what's causing the problem is you've been for it for quite a long time.
Yeah, I know.
Right?
I know.
All right, so I'll set it there and she may at some point say she's not representing you and then we'll have to try to deal with how we go about doing that.
Okay.
All right.
Thank you.
Thank you, Your Honor.
Thank you. Which are who?
Vincent.
You know, I walk in and when I see the list of attorneys, what? No, it's not a bad joke. No, it's just my life. I'm going to explain to you something. And I look at the list of attorneys and I think, this is going to be a good day. None of these attorneys are going to cause any problems. They're going to just go out, do their job. Things are going to run smoothly just because of who they are. But inevitably, there's always one or two attorneys that for whatever reason, their day is just going that way. Today's mishap. It's like, for whatever reason, you call your case, your client's first on a bus. He got here. No, we waited. And he was in a suit. He's in a suit, got here. So then I called this other case. And wow, that was a deep breath. And we don't have your client. So what would you like me to do on that? Okay, well, you think about that answer. Ms. Ekenrulli, the case I had you pass, because you're always a problem, so I just have low expectations. Have you had a chance to talk to your client?
I have, Judge.
Huh?
I have, Judge, yes.
You have? You want me to call it or you?
We can call it.
Yes. Court recalls the case of the people versus Jody Ann Russell.
If you were to the for the people.
and Assistant Public Defender Chinazi Kyriakin on behalf of Ms. Jody Ann Russell. Jody, state your
Your
name.
name again?
Jody Ann Russell.
Thank you.
So, Your Honor, thank you for the bench conference. I did have an opportunity to speak with my client. Maybe we should approach Judge, please.
All right. All right, we're back on the record in the Russell matter. Record truly reflects we had two bench conferences in this case. I will grant the adjournment in this case. So I'll adjourn. Are you trying to do a whole mediation report with her?
We're gonna need it. Yes, Your Honor.
So I'll go to June 26th. I'll adjourn it to June 26, 2025, 9 a.m. I will have her bond continue in its monetary form and other conditions. I'm going to add two conditions to it. And that is that two no-goes. So you are not to go to Tonda Elementary School in Canton. You understand that, ma'am?
Yes, sir.
Or to Pioneer Middle School. That's also in Canton.
Yes, sir.
Okay, you understand that?
Yes.
That's all I'm gonna do at this point. Otherwise, I will continue.
Thank you, Your Honor.
Thank you. I even talked real slow in that case too, most of the time. So, no, here's what I'm gonna do. Here's what I'm gonna do. Because I have faith because of the gentleman that showed up on the bus. Do you have a belief that Vincent's gonna be here, or you don't know?
I don't know, Judge. I would love to say I have all the faith, but I don't answer my calls or texts.
Okay, well, why don't we just call it? And I appreciate your candor on that, Ms. Staffel. Court does recall the case, People versus Vershawn Vincent.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent. Judge, I did have a chance to speak with Ms. Londy regarding a potential resolution for this case. An offer was extended that Mr. Vincent was entertaining. I had discussed on the break with him. I had a phone call. I don't know what happened to him and his appearance now. He did inform me that he was released from the hospital yesterday and was having some medical issues, which is why he wanted to adjourn to consider the offer and didn't want to make that decision today. But he's no longer responding.
All right. I'll issue a benchmark for defendant Terry to appear. Bond will be setting him at a 10,000. Cash surety. What I will do, Miss Apple, is I won't. Let's say the 29th. I won't issue the warrant until June 2nd. Give it a chance to try to get through him since you talked to him today.
Thank you. I appreciate that.
All right. Thank you. That ends that block.
When's my next block? Your Honor, and I approach on an unrelated matter with
Who?
Mr. Kennedy, myself and Mr.
Oh, I thought I had avoided that successfully, but apparently not.
Sorry.
Okay, come on.
Yeah.
I'm just saying. Okay. Court stands in recess.
Hello? Hello? Who is this?
Hi, this is Janet from Accident Care Service. How are you?
I'm fine. You can take me off your calling list.
Want me to sing? I can sing a song.
Fourteen A District Court for County of Washington, State of Michigan is now back in session. The honorable Judge
May be seated. Court does call the case, People versus Marcus Earl.
If you represent for the people.
And good afternoon, Your Honor. Brendan Walsky appearing on behalf of Marcus Earl. Your Honor, my client is not present here in the courtroom. Today is a date and time set for a PCC in this matter. I've made multiple attempts to try to contact my client. I've discussed this matter with his mother multiple times. Unfortunately, he refuses to communicate with me. Based on some of the background information I have regarding this serious mental health issues that he suffers from, I believe it would be best suited at this time, and I brought it to Ms. McDuffie's attention, to possibly refer him for competency. It's my understanding that he's on Zoom right now.
He's not. You know, you have him logged in?
Yeah, it's a woman, there was a man, but yeah, they might be frozen.
Oh, so you think they're here?
Yes.
I'm not picking it up on my screen.
Up top in the middle, Your Honor.
Gotcha.
Yeah. Yeah, they're frozen.
Frozen. So he actually may be here.
Correct.
Well, just dropped. Okay, so why don't I pass it, see if they sign back in?
Okay, thanks, John.
Let's call the case of the people versus Brandon Clemens.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Attorney Jonathan Paul for Mr. Clemens. Brandon, please turn your camera on and mute yourself.
Yes, sir.
Please state your name.
State your name.
Brandon Clemens.
Thank you. All right, what are we doing?
Your Honor, I've had good conversations with Ms. Landy about this case. I'm going to be asking for an adjournment. I'm in communication with the sobriety code of the 15th District Court. We've had productive conversations. I've shared with Ms. Landy that Mr. Clemens has completed a Dawn Farms program. This case is about a year old. We continue to have productive conversations about this case. I believe Ms. Landy wanted to address bond, but it's my understanding that Mr. Clemens is on a portable breath unit through community corrections. I'm not aware of any violations. I think he's doing well on that. We'd ask the court just to continue bond.
I will adjourn the probable cause conference to June 17th, 2025 at 9 a.m. Esteban.
Your Honor, this is an operating while intoxicated with an occupant less than 16. The second offense notice has been filed. The defendant in this case was observed operating the motor vehicle by the police and then pulled into a parking lot and hit a parking object, like I think a divider or something to that effect. Had a 5-year-old child in the car. His BAC was found to be 0.248. He also had amphetamines present in his blood. I'm requesting he be placed on a scram. I believe he's on a SoberLink testing only twice a day. And I am concerned given the extremely high blood alcohol content and the child in the car that he should be on that scram tether.
When his prior was in 19?
Yes, Your Honor, 2019.
If I
Any
may
response?
Yes,
to
Your
that?
Honor. As noted, this case happened about a year ago. Mr. Clemens has not been in any further trouble. As noted, I did share with Ms. Landy, he has been in a intensive Dawn Farms program. It was a 30-session program starting in April 16th, 2024. He was placed on the SoberLink unit by the magistrate about 2 weeks ago. There's been no issues with testing. We'd ask that the bond be continued. There's no reason to believe that Mr. Clemens is consuming alcohol testing twice per day. If the court wishes to test him further 3 times per day, there would be no objection there, but we believe the current bond is appropriate, Your Honor.
Having heard the argument, the court will not place him on a scram at this time, but I will increase his testing to 3 times per day on the SoberLink unit.
Thank you, Your Honor.
June 12th was our date, Your Honor?
Yes, June 17th.
Oh, thank you, Your Honor.
Thank you, Your Honor. Mr. Clemens, you can sign off. Ms. Landy, I'll follow up in a bit. Thank you.
Thank you. And he needs to contact community corrections. We'll be sending over an order shortly.
Thank you, Brandon. I'll send that over when I receive that to you.
I got it.
Okay. Court does call the case of People versus Christopher Jackson.
Good afternoon, Your Honor. My name is Claire Lowe, and I'm
Who?
Claire Lowe on behalf of the people.
Requesting permission to practice pursuant to Michigan Court Rules 8.120 under the supervision.
Whoa, back up. You guys start again.
Covered on behalf of Mr.
No, she's got to start again.
Oh, let's go.
8.120.
Yeah, start all over.
Name is
O is a letter. Zero is a number. Go ahead.
Good afternoon. My name is Claire Lowe. I'm from Mountain People, requesting permission to practice pursuant to Michigan Court Rule 8.120 and under the supervision of Assistant Prosecuting Attorney Alexander.
Oh, that might explain it. Where are you from?
From Ann Arbor.
You are? In Ann Arbor, girl. All right. What high school?
I'm here.
She wins. You're done. Whatever she wants, she gets. Pioneer, fantastic. And where'd you go to undergrad?
Michigan State. Does that ruin it?
Yeah, pretty much. Pretty much. Not as bad as the Badger lady. I don't know. And you're in law school where?
Wayne State.
Then you just made up for it. That's where my son goes. So you're good. All right, fantastic. Permission to practice is granted. Welcome aboard.
So Judge, after all that, I can't object to it.
What?
I suppose after all that, I can't object to it.
Oh, you could, but
No, I'm not going to. Fair enough. We're just asking that this matter be set for preliminary exam.
Oh, your discovery is complete.
Yes, Judge.
And would the people have their witnesses available to tap?
We'll do our best, yeah.
All right. Preliminary examination will be set June 10th, 2025, 9 a.m. That is before Judge Valva.
Thank you, Judge.
Bond will continue. Thank you.
All right. Thank you, Judge.
Court calls the case of the people versus Bianca Rao.
On behalf of the people. Kyle Brill, on behalf of the defendant. Ms. Rowell, please introduce yourself to the court.
Hi, I'm Bianca Rao.
Good afternoon, I guess. All right, what are we doing?
Your Honor, so we are here for probable cause conference. The people extended a rather generous offer that requires Ms. Rowell to complete some things. It also requires some records from her employer, which is being rather difficult for me to get a hold of. We are asking for just another adjournment at this time. I know there's been several, but
No, that's fine. In terms of what she has to do, how much time is it going to take?
I think what she needs is about a week. I think the working with the bureaucracy might take a little more time. If the court could give us 30 days, if not, I understand.
How do you go from a week, 30 days?
Well, she needs a week. I need 30 days.
Well, that's a you
her
part. All right. Here's what I'll do. Probable cause conference. Now, 17th. June 17th, 2025. 9 a.m. That's a Tuesday.
Thank you, Judge.
All right, thank you. Bond will continue. Calls the case, people versus Dijon Williams Watkins.
Good afternoon, Your Honor. Edward Taylor, P571166, appearing on behalf of John Williams Watkins. State your name for the record, please.
John Williams Watkins.
Thank you. Your Honor, he has a criminal responsibility exam scheduled for June 29th. I just saw the other day, we were still on the docket. I thought they would have notified the court. So we need to get this adjourned to.
Well, criminal responsibility would not be dealt with at this level. You deal with it at the circuit court level.
Really?
So.
Okay.
We usually don't await those reports. We deal with the forensic as regards competency.
Well, I got a notice from the court. Okay, so we'll set this for, I guess, exam, yeah.
All right. Discovery is complete.
Yes, sir. You want to see what I got?
Go ahead.
Just a second.
Yeah, just go ahead and set it.
Okay. Yes, you're gonna set an exam date, yeah.
And you have all of the discovery, sir.
I do.
People have their witnesses available the 10th.
We'll try our best.
Preliminary examination, June 10th, 2025, 9 AM. That is before Judge Barr.
Judge who?
Barr.
All right, thank you. All
B-A-R-R.
right, good seeing you.
Good seeing you, sir. Bond.
All right, thank you.
Court does call the case People versus Anjanae Yancey.
Hey, Pierre Richmond, that's for the people.
Good afternoon, Your Honor. Edward Dukes on behalf of the defendant. I'm standing on the record.
Hello, Angela Yancey.
And I have a filled out agreed form. There's continued negotiations. We're asking for 2 weeks.
Probable cause conference, June 12th, 2025, 9 AM. Bond.
Thank you.
Let's call the case People versus Corey Craig. Oh, she's back. She's up again. She's done. She did everything.
Oh,
I only needed one.
Oh, okay. I didn't, some judges required every.
I know.
David I. Goldstein appearing on behalf of the defendant. State your name, sir.
Corey Craig.
Sending this matter for preliminary exam of all the discovery.
Other witnesses available the 10th? Preliminary examination, June 10th, 2025, 9 AM. That will be before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jason Thomas.
David I. Goldstein appearing on behalf of the defendant. Mr. Thomas, state your name, please.
Jason Thomas.
Same with this case, Your Honor. I have the discovery and we're asking for a preliminary examination.
People have their witnesses available to 10. Preliminary examination in person at June 10th, 2025, 9 AM. That is before Judge Barr.
You're all set. I'll call you.
Bond will continue. Thank you.
Thank you, Your Honor.
Calls case People versus Armani Taylor.
David I. Goldstein appearing on behalf of the defendant, standing in for Sydney Rushing today. Your Honor. Ms. Taylor is aware of that and she has no objection.
Is that correct, ma'am?
Yes,
All right. Your name?
Armand Taylor.
All right. What are we doing?
Ms. Rushing asked me to have this matter set for a preliminary examination, but she is not available on the 10th. She asked for the 17th.
No, okay. You believe she has all the discovery?
Yes, Your Honor.
All right. And what date was she looking at?
The 17th.
17th. Any objection from the people?
No objection, Your Honor.
Preliminary examination in person will be set June 17th, 2025, 9 AM before Judge Moore.
Thank you.
Bond will continue. Thank you. Cross case of the People versus Tayana Beasley.
That's for people.
Yes, Your Honor. Brandon Bird on behalf of Tayana Beasley. Ms. Beasley, can you unmute yourself and state your full name for the record?
Diana Beasley.
Thank you. All right, what are we doing?
We'd like to set this matter for a preliminary exam, Your Honor.
You have the Discovery Council.
I believe I have all of it, Your Honor.
All right. People have their witnesses available to 10th. Preliminary examination, June 10th, 2025, 9 AM. That will be before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
Calls case of the People versus Brianne Caldwell. Cadell, excuse me. You're back.
Yeah, yes, Your Honor. Brandon Bird on behalf of Breon Cardell. Ms. Cardell, can you please state your full name for the record?
Brianne Cadell.
All right, thank you. All right, what are we doing?
We'd like to set this matter for exam, Your Honor.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 10th? Okay. Preliminary examination in person, June 10th, 2025, 9 a.m. That is before Judge Barr. Bond will continue. Thank you. Court calls case People versus Lauren. I'm going to say Lauren McEwen.
This for the people.
Yes, Your Honor.
Mr.
Brandon Bird
McEwen?
Yes, Your Honor. Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please state your full name for the record?
Leon McEwen.
All right, what are we doing?
Your Honor, respectfully, if I could just get a little bit more time to talk to the prosecutor. I know I did talk to my client and speak with Sister Prosecutor about an offer to potentially lower this to a misdemeanor, in which my client would be ready to plead to, but unfortunately I couldn't be there today due to being in circuit court. And we just asked if I could please just get a little bit more time to speak
June
with Sister Prosecutor.
17th. June 17th, 2025, 9 a.m. That's a Tuesday, counsel. Okay.
All right, Jim.
All right, fine. Continue. Thank you.
All right, thank you.
Thank you, Your Honor, and you and Your Honorable Court have a great day.
You do the same, sir. Court does call the case, People versus Elliott Kazan.
Christina Bergera for the people.
Wow, how'd you get over there? What, did they kick you out over there?
No, Your Honor.
So why are you over there?
I'm with Ms. Lundy, Your Honor.
Why is she?
There's a lot of us.
There are, this place is packed with prosecutors.
For the record, Your Honor, Joe Simon, on behalf of Mr. Kazan, state your name, please. Elliot Kazan.
I'm presuming you have the violation.
Yes, Your Honor. We.
Why don't you approach?
Yes, that's what we're going to ask. Thank you.
Mr. Allen.
Apologize, what takes? Okay.
All right. In this case, we do have a bond violation report, which indicates numerous missed tests. But then makeup tests were negative for alcohol or late test, with the exception of the 24th, at which point there was a missed test, retested, and showed up with alcohol in the system.
Your Honor, I've discussed these issues with Mr. Kazan. He's going to admit to the court to consuming alcohol. I don't know if it was the 23rd segue into the 24th, but whichever that day, in violation of his bond, he's going to not try to deny it. He's going to claim full responsibility. We have some requests as a result of that, but first, I think that he's ready to address his.
And that's correct, sir. You admit to this violation?
Yes, Your Honor.
I will not take his plea today. I will adjourn the probable cause conference out to June 5th, 2025 at 9 a.m. And what did you want to say before I sent him?
Your Honor, my client has been screened and assessed with Matthew Statman. That's the provider that the remand court uses. He has made arrangements for his recommended outpatient treatment. It took a while due to backlog, but he's pushed it up and he's got, if the court would permit him, 9 a.m. tomorrow at UMass which is the University of Michigan Alcohol Treatment Services or something like that, or I can't remember the full acronym. Anyway, at 9 a.m. is his intake. Additionally, I told him that continued SoberLink testing is not recommended for him, that even though it's summertime, scrams can be uncomfortable, particularly when we stop wearing long pants necessarily, and et cetera. That would be the only thing that the court might entertain in terms of making sure he's not a risk to others or a danger to himself. He said he would happily do that immediately, turn in his SoberLink and put on a scram and wear that. So that is our request, Your Honor. I told my client that the court in this situation typically revokes somebody's freedom, revokes their bond and puts them, incarcerate them. He's prepared for that eventuality, but hopes the court will consider our request, our alternative request.
The court looking at it, and we had a bench conference about this, I think, when I looked through and there's a missed test. I also am concerned with the fact of the blood alcohol level at 10 o'clock a.m. testing, which tells me that there's probably a whole lot more going on because he had previously missed the other, or had missed the testing at 7 a.m. So when I look at it all, that seems to me to be a big problem in terms of a gap. And I think there was a lot more alcohol consumed than what this one PBT indicates. At this time, given that the defendant has admitted to the violations and violated his bond, the court is going to revoke the defendant's bond. Defendant's remanded to the Washington County Jail. So we'll see next.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Mayao Wang.
Good afternoon, Your Honor. Uwe Daus on behalf of Mr. Wong. Marian, please unmute and state your name.
Good afternoon, Your Honor. Maoyuan Wang.
Thank you for the remote attendance. I did submit a green sheet for PCC adjournment. I don't know if that made it into the file.
I'm down
we're
one
looking to
staff member,
adjourn
so I
once
probably
more.
don't have it, but you're looking to adjourn this?
Yes, please, for continued discussion with the prosecutor's office and outside counsel.
How much time did you need?
I was thinking 2 weeks. That's what I hope we would need, no more than that, if that's a suitable date.
June 12, 2025, 9 a.m.
Very good. Thank you.
Thank you, Bond.
Thank you, Ron.
Thank you.
Thank you.
Pardon?
I do have his green sheet.
You do? Okay. Court does call the case of the People versus Chloe Whitsett.
Andrew Childers, apparently on behalf of the people.
Good afternoon, Your Honor. Kia Hickman on behalf of Chloe Whitsett. Ms. Whitsett, please state your name for the record.
Chloe Whitsett.
Hello, Ms. Whitsett. How are you?
I'm here, Your Honor. Thank you.
So Your Honor.
What are we doing?
Yes, Your Honor. So we do have an update. Ms. Whitsett has started the onboarding process with 36th District Court. She's in that phase to where they're still trying to assess which one will be better for her. We found out that she's a veteran, so they're looking to place her in Veterans Court over Mental Health Court because she could get multiple needs met, including mental health, in Veterans Court. We have a date with that court. One moment, Your Honor.
I believe it's the 10th.
June 10th. There's a date with that court in which they'd be looking to officially admit her into that court. So I believe we'd have to set a date between now and then with this court to sentence her to mental health court in Detroit. So I'm not sure if we want to do that on June 9th or 11th, but it may need to be in person since there is a restitution amount that we need to handle as well.
Okay, so she's been accepted into the Veterans Court there?
She's in the onboarding process and the acceptance date is June 10th. the way they do it is a judge like enters you in. Like you go before the judge, it's like a hearing, and that's when they accept you into mental health court. So right now she's in the onboarding process. She's done her interview. She's made one appearance in court already, and we've been talking with her case manager as well. So she's accepted, but there's not an official acceptance until June 10th, if that makes sense.
Got it. So what do you need to have happen here before June 10th?
Well, I believe prosecution wants her sentence before she's fully transferred to 36th District Court because of the restitution part.
Right. Okay, so here's going to be the problem.
Mhm.
Even the judge, who's well, is that whose case this will be?
Yes, sir.
It would need to get over to Judge Valvo to do that, and we'd have to try to do that all before the 10th. And I'm not sure what date. I'm just checking, seeing what dates they gave us for her sentencing dates.
So they only gave us one date, it's June 17th.
The only date they've given us is June 17th.
If I could get an
go ahead.
adjournment, if I could get an adjournment for the June 10th date in Detroit, would that work for this court?
I don't see why it wouldn't. I think we certainly could do that. The other thing that I could do, since this is Judge Valvo's case, is I can adjourn this out 1 week. You can try to get the adjournment, and I would see whether or not she would have any objection to my sentencing the defendant on that date
Okay.
to try to get it moving.
And we would need to be in person for that then, correct?
Yes.
Okay.
And that's, my next date would be June 5th. But I know you've been working hard on this, so we'll work. If you contact my staff, we'll make sure that you're in a block that will work for you, counsel.
Thank you,
get here.
Your Honor.
All right, since you didn't yell at me today. No.
I never yell. I don't even know.
Yeah, I
how to
know
yell.
it. It never seems like that until you're on the receiving end. All right. Adjourn it out a week, and I'll try to get through, we'll see if she has a problem. We'll explain all of the circumstances
Okay.
and see if she has a problem. So at worst, if I don't have a date with her before your adjourn date, then I can do the sentencing.
Okay, great. And June 5th looks good for us. For me,
All right.
looks good. Yeah.
Okay, then what I'll do is I'll set the probable cause June 5th, 2025. I'll set it at 9, but of course you'll get the block as to what time you're in.
Okay.
And her bond will continue. Ms. Whitsett, we've been dealing with each other a while. I didn't know that you were a veteran.
Yes, sir.
What branch?
The Army.
Okay, I'm not gonna hold that against you. But I'll just thank you for if I don't get an opportunity, thank you for your service, because it's people like you that doing what you did that allow me to do what I'm doing. So I'm always cognizant of that. All right?
Yes, sir. Yes, sir.
All right.
Thank you.
Thank you. We'll see you guys next week then.
Thank you, Your Honor. Have a great day.
Thank
To
you.
your staff.
You too. All right.
And you, Mr. Prosecutor, as well.
All right. Yeah, that's all I've got. Are you ready? Where's it?
They did not sign back yet, his client. So as ready as they're gonna be.
They're ready. Court recalls the case B versus Marcus Carl.
Mr. Earl,
Earl.
Rachel McDuffie for the people.
And good afternoon, Your Honor. Brendan Dabalski appearing on behalf of Marcus Earl. Your Honor, as you're well aware, we're having difficulties getting my client on Zoom. I know that when you had originally called this case, it appeared that he was on Zoom with his mother. However, they
were frozen.
Correct. There's been multiple texts to me from the mother as we had been waiting for them to connect, and they're having tremendous difficulty. Nevertheless, I don't know how Your Honor wants to proceed with that today.
Well, given the fact that they were here, I'm not gonna, and the other issue in the case, I'm not gonna issue a bench warrant. What I'll do is I'll adjourn this out. Let me adjourn it out June 12th, 2025, 9 a.m. Does that work for you, Counsel?
It does, and I know Your Honor is always great about this, you and your staff. Is it possible I can make my request for Zoom right now as opposed to submitting the document, or do you want me to go through and submit the request? Okay, I'll do that.
Continue.
Thank you, Judge.
Thank you. Yeah. Wow. I almost finished up early. Who's my bond motions?
I believe it's on Burns.
Okay.
Here on Miss Towers. Mr. Bukovich should be back on Mr. Johnson.
Okay, so I got all those. And then who's on the other side of the other?
Ms. Tanha, Ms. Zenda, and Ms. Bukovich.
Miss Tana here?
She's on.
She's on her way. Oh, joy. Anyway, okay. I didn't mean it that way. All right, then before I go into recess, who are the, see, you guys are so rude. Just like the PD's office. I'd like to be introduced to the people that are appearing before me before they appear before me necessarily, but I did. You're right. You, because Londi knows.
I tried really hard. Thank you.
Zenda, bring your intern up. Who else is here? Come on.
Do you want white noise, Your Honor, or you just want to go off?
Let's go off. We'll go off. I'll stay in recess. Yep, I got it.
It just,
Fourteen A District Court for County of Washington State, Michigan, beyond the base.
what do you want? Okay, so you want one from this morning?
Yeah.
Then I gotta call.
You may be seated if I didn't say so. I see you show back up. Court does call the case of the people versus Stephen Johnston.
Okay, Rachel McDuffie for the people.
And Allison on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Johnson.
All right, I put this over to this afternoon. What have we determined?
Yes.
Good evening. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up.
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give the change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name? Yes. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Kunke there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, between the time of Judge Kunke's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
While context may be changed, he has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a violation of his previous probation. So
right, okay, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case.
Yes, I understand what you're saying, yeah.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waving up.
Yeah, be getting in front of Kunke.
You know what, Your Honor, I might as well just wave up to Kunke.
Okay.
Okay, if that's what you wish to do. Sir,
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening. So I would still be asking for a.
You're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Otella, Mr. Bukovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this is prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised the red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that The circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now. So the people are, again, requesting a simple, but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
All right, here's what the court's gonna do. Well, is he waving up or what's he gonna do?
He's being funky.
Or did you wish for the adjournment, Mr. President?
Your Honor, I'm quite confused on a couple of things, if I'm able to speak to you for a second. The complaining witness of who they are talking about, I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Conkey, Judge Conkey, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Conkey's courtroom, Your Honor. And by me not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with a
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
What she did?
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm not able to have contact with her. She didn't put me in this predicament. Her doctor
Sir, I
did a
advise you to stop
welfare
making
check on her.
statements. I advise you to stop making statements, because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No,
waiver?
give me the pen.
He's-
I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm not taking his waiver. I'm just gonna adjourn this out. You can talk to your client and he can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me. I don't even know why. I'm making the findings based upon what's presented to me. But if he's gonna act this way, I'm just not having it. So.
Would you like to briefly pass this matter so I can speak to my
No,
client?
I'm not gonna pass it. I'm gonna adjourn
not
this
mad.
to another day.
I'm not mad.
I'm going
Not
to
upset.
adjourn this to. Give him 1 week out. We'll go June 5th, 2025, 9 AM, or
Mr.
as his
Simpson.
invite indicates. I am at this time going to change the bond conditions. I'm gonna leave his bond in its monetary amount as it's set. I am gonna order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also gonna indicate that there's no contact with Christian Kanuski. I'm gonna order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm gonna put up with his behavior, I'm not doing it. I'm
Your
done.
Honor,
Thank you.
I'm not upset, Your Honor. I said just. Okay. Not even upset.
Yeah. I think people want to see what my face looks like right this moment. Okay. Court does call the case People versus Angelica Towers.
And is that on behalf of you, Your Honor?
Good afternoon, Your Honor. Edward Drukes on behalf of Angelica Towers.
Angelica Towers.
Thank you. All right, go ahead.
Your Honor, she is going to be signing a sentencing judge waiver. This is, I believe, the Scioto Township case. So I believe it would go to, would it go to Fresh Hour?
It will go to Judge.
And she's signing the advice of rights indicating that there would be a plea today to count 2. Counts 1 and 2 would be dismissed at sentencing.
And Your Honor, counts 1 and 3 would be dismissed.
Or 1 and 3 would be dismissed.
So she's going to plead guilty to count 2.
And there's no objection to HIDA. And I understand from the prosecutor.
That's correct, Your Honor.
Ever sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Angelica Towers.
And it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, $200 or more, but less than 1,000.
Yes.
All right. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Now, understanding all of that, do you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today.
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will? And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 18, 2025, at the location of Jackson, 6655 Jackson Avenue, Unit 680 in Scioto Township, Washtenaw County, State of Michigan. What you do on that date involving the, I guess, the property, the car tires of a Mario Simpson, and that would indicate no relation to me. That makes you think that you're guilty of this offense.
Yes. I popped his car tires.
Okay, how'd you do that? You had a knife and you just popped them?
Yes, Your Honor.
All 4 of them?
I don't remember.
Okay, but you at least did one. Would you agree? Well, you had no ownership interest in the car or those tires, is that correct? Pardon?
No.
Well,
But yeah, that is correct.
yeah, thank you. All right. And you did it intentionally, correct? Would the value of the replacement for those tires, would that be in excess of $200?
Yes.
Yes. Okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing will be
July 1st at 9 a.m. with Judge Freshour.
July 1st, 2025, 9 a.m. in Chelsea.
And Your Honor, I'd like to address bond and
Yes, you may.
approach with the prosecutor.
Go ahead. You may. All right, record should reflect we're back on the record in the case of Towers. All right. Is there anything additional on this?
Nothing. I just thank you for the conference, Your Honor.
All right. Bond in this matter with its conditions will continue at this time.
Good, thank you.
All right, thank you.
Thank you, Your Honor.
Does call the case of the people of the state of Michigan versus Jerome Burns.
Good afternoon, Your Honor. Rich House, Assistant State Attorney on behalf of the people.
And Assistant Public Defender, Chinazi Kyriakin, Your Honor, on behalf of Mr. Jerome Burns. Mr. Burns, would you state your name for the record, please?
Jerome Burns.
Your motion.
Can we? Hey, approach Judge.
I've been, people have been approaching all day. Come on.
Thank you for that, Your Honor. Your Honor, obviously, we're here today. The people filed a motion for a bond violation revocation.
Yes.
It was an emergency bond motion, Judge. I have had an opportunity to review the details of the motion as well as the supplemental report that was accompanying it with my client. My client would like to enter a plea to the violation of his bond in this matter. It would be a no contest plea. We are satisfied with the court using the information, the supplemental report as the basis for that.
You understand that, Mr. Burns?
Yes, sir.
You understand that I will accept the facts that are contained in here as true.
Yes.
And you do not wish to have a full-blown hearing on this, sir?
Do you wish to have a hearing on this?
Is it what we just talked about?
A hearing is where we have testimony. When somebody comes out and says,
Yeah.
wish to have a hearing, is that correct? If you don't have a hearing, that means you're pleading guilty to it.
Yeah, yes, Your Honor.
Yes, sir.
I'm not gonna do the hearing.
You do not want the hearing on this. All right.
Your Honor, if I may, before he enters his plea, we discussed at the bench and I informed counsel this morning, there's also an additional statement. We want to make sure that's part of the record.
Yes.
I missed it in the written motion, and it is on the jail call provided. Defendant made a statement that if he is released from custody, that he would take the child that he shares in common with the victim away from her and leave, and the victim would never see that child again.
And Your Honor, I just, again, we're not disputing any of the information that's been provided, Your Honor. I think that it is important that we, for the sake of the record, clarify the intentions behind that particular statement. It was made. We're not disputing whether or not it was made. There is a difference in parenting. He does not, parenting styles, I would rather say. He has spoken to me previously about his views on parenting style and how they differ between he and his wife. He tells me that that particular statement was because he felt that the child would be better with him if that were to happen. If obviously they would have to go through family court and fight that matter out. He never intended on kidnapping or stealing or doing anything illegal as it pertains to his child. He has told me time and time again, he sheds many tears when it comes to his child and his child's health issues and what they have been through as a whole. As a family, dealing with his child's health issues, Judge. So that does not change our position today.
Can I just say, I'll let you go on, counsel, but I'm having a problem with that.
Okay.
Because I've listened to his phone conversations provided to the court in preparation for this hearing. I look at the words that he uses, and that sentiment does not by any means fit with anything that he has said at all.
I completely understand that, Judge. I know that when it comes to when we're given the opportunity to elocute on his behalf, Your Honor, there is some information he'd like for us to provide to the court. I don't know how helpful that is going to be, but I completely understand the court's position.
Your Honor, after that, I'd like a chance to respond if I may.
Now, here's what I'm gonna do. I'm going to to the bond violations regarding the contact, attempted interference in the case, comments regarding the court, also attempts to interfere with the orders of the court, and the statements being made and attempts to make direct or indirect contact with the victim in this case. How do you plead to those?
No contest.
No contest.
I wasn't going to sentence him at this point in time. He is set for PCC next week in any event. So I was going to move any sentencing or anything that the court's going to do at that time, hear any statements that counsel wants to make, as well as any additional information for the people at that point, if that worked for everybody.
That's fine with us, Your Honor.
That's 6/5, right? So the probable cause conference, which has already been set for 6/5/2025 at 9, continue to that day, and the sentencing on bond violations will be set at that time. All right.
Thank you very much.
At this time in the interim, however, what I am going to do is
Next week.
I am going to, given what the court has heard thus far, I am going to revoke the defendant's phone privileges at this time, however. Thank you. Bond will continue in all other aspects.
You get it covered.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.